Item number 1, CRLA 19 of 2004.
The appeals are dismissed. The time to surrender is 5th September.
Item number 2, CRLA 184 of 2012 and batch of matters.
The appeals are dismissed. Time to surrender is 5th September.
Item number 3, WPC 17710 of 2012 and batch of matters.
The writ petitions are dismissed. Yeah.
Specialist for hearing item number 1, CRLA 151 of 2005.
Yes. No, this is the premature release. The appellant has already been released prematurely.
Even the by high
The sole appellant, I think. So same order. The appeal is disposed of. Yes.
Specialist item number 2.
Here again, it's a single appellant, is it? Who's for the state in these matters? Ms. Katke is not here. All right, same order. Sole appellant.
Specialist item number 3.
Item 3 Mala, this is sole appellant.
Sole appellant, correct. Same order.
Specialist item number 4.
Sole appellant. All right.
Specialist item number 5.
item number 5, sole appellant. I am
Right. Right. All right. Disposed of.
Specialist item number 6.
Sole appellant.
Sole appellant. Same order.
Specialist item number 7.
Several, my lord, I am appearing for the appellant. Already released from the.
Correct. Same. All right. Same order.
Supplementary list. Supplementary list, old matter item number 1.
My lord, on behalf of Mr. P.K. Satwati, no instruction. I am.
No instruction disposed of. Right.
Supplementary list item number 2.
My name may be recorded as opinion opposite party.
All right.
Oblige, my lord.
Item number 2. WA 159 of 2013.
None appears dismissed in opposition.
Supplementary list item number 3.
Item number 3 may be passed over. This
All right.
understanding.
Supplementary list item number 4.
Item number 4, I have no instruction, my
No
lord.
instructions disposed of. All right.
Supplementary list item number 5.
No instruction.
No instructions disposed of.
Supplementary list item number 6.
None appears dismissed in opposition.
Supplementary list item number 7.
None appears dismissed in opposition.
Supplementary list item number 8.
None appears dismissed in opposition.
Supplementary list item number 9.
None appears dismissed in opposition.
Supplementary list item number 10.
None appears dismissed in opposition.
Supplementary list item number 11.
Lordship not pressed disposed.
Supplementary list item number 12.
None appears dismissed in opposition.
Supplementary list item number 13.
None appears dismissed in opposition.
Supplementary list item number 14.
None appears dismissed in opposition.
Supplementary list item number 15.
Item number 15. I filed this case. The distribution of compensation was improper. Out of 4 dependent, 5 dependent, court below though matter has disposed of in the low court of, but out of entire amount, the wife who is not at all dependent, after death of the 6 months, he left the house, remarried there, and distribute the amount in favor of 2,70,000 and rest 1,30,000, father, mother, and an unmarried daughter. So being aggrieved that, I filed a case for consideration that now, for properly consideration, I here to file this. Constitution distribution not proper. Unmarried daughter, he get only 20,000. Father 20,000. In the meanwhile, father also dead. And that amount he is not enjoying that FD amount, he dead out of a mournful situation because he not collect money to give marriage of his daughter. So my response on them, the amount 4 lakhs, that contribution should be proper. That
should be
amount
proper? But it's already, there's no stay of the impugned order, sir. 2013 matter, all the distribution must have happened already.
amount remain fixed by the court below is back. 1,50,000.
No. Impugned order, the single judge. Come to page 11.
Yeah. Yes. Amount disbursed, but out of that amount, every amount 1,50,000 remain in the name of wife in the nationalized bank under the lower court at Jagatsinghpur.
So why don't you read the order?
Yes, the order on peruse of the impugned award, it is seen that out of total completion amount 4 lakhs, the Law Tribunal has directed to deposit rupees 150 in the name of Manju Ale Shanti, who is the wife of the deceased. Law Tribunal further directed to deposit rupees 20,000 in the name of Muralidhar Malik, who is the father of the deceased. Rupees 20,000 in the name of Uli Malik, who is the mother of the deceased. Rupees 30,000 in the name of Mami Malik, who is the sister of the deceased. Rupees 20,000 in the name of Pramod Malik, who is the brother of the deceased. Law Tribunal has further directed that out of the balance amount, rupees 1 lakh to be paid to the wife of the deceased. That has already gone. And rupees 20,000 each of the petitioner father and mother. My responsibility is 1,50,000 who remain in the bank. That's the hand of the court. If you lost it direct, that court will redistribute that amount.
No, why? This order has not been stayed. This order of 2nd August has not been stayed.
I filed in the court for a redistribution or matter dispute local. That has dispute local out of a settlement.
No, sir. This order of single judge has not been stayed by the division bench.
No, that is not.
If it has not been stayed in the last 9 years, it's all over, sir. Nothing will remain. Now we will ask people to pay back.
But because I have been directed to make the wife as party, then I have sought that for that I have not because you will also direct required.
Yeah, this writ appeal is by the parents and siblings of a victim of a motor accident. Deceased victim of a motor accident is directed against an order dated 2nd August 2013 of the learned single judge, dismissing writ petition civil 2199 of 2013 filed by them, challenging an order dated 22nd November 2012 passed by the 3rd MECT Jagatsinghpur in MEC number 400 of 2010, apportioning the awarded amount among the claimants. Paragraph. The total compensation awarded was rupees 4 lakhs, with the parents getting rupees, with the father getting rupees 20,000, the mother getting rupees 30,000.
20,000. Sister.
No. Uli Malik is the mother.
Uli is the mother.
Mother. She got 30,000, sir.
Yes.
Please don't interfere. I'm dictating. Kindly do not interfere.
Sorry, ma'am.
Rupees 20,000. You see, the compensation amount was distributed with order to be distributed with rupees 20,000 each to the parents, rupees 30,000 to the sister, and rupees 20,000 in the name of the brother. Full stop. Rupees 1,50,000 was 1,20,000 was directed to be paid to the wife of the deceased from the balance amount, and rupees 20,000 each in favor of the parents. The grievance is that the amount asked to be placed in the fixed deposit, that is rupees 1,50,000, the name of the wife of the deceased, should be asked to be distributed amongst the others as well. Paragraph. It is seen that during the pendency of the present petition, there was no stay of the impugned order of the learned single judge. Full stop. Therefore, the impugned order should have worked itself out. Full stop. In any event, considering that the amount has been asked to be distributed in favor of the wife of the deceased, with others getting reasonable sums in equal proportion. The court sees no error committed by the learned single judge in declining to interfere with the order of the MACT, Jagat Singh Poor. There is no merit in this appeal and it's dismissed as such.
Supplementary list, item number 6.
My lord, sorry, if you made a mention.
20,000 remain the father are dead. That amount be released in favor of his wife. Father dead. Petition of
They're not adding anything more, sir. Already whatever is there is there.
Item 13, the last matter we taken off.
Sorry?
Item 13, I could not. Item 13, this is the 14, my matter is 13.
Yeah, tell us.
Sir. 13. My lord, the appeal arises out of the order passed by the Honorable Single Judge. My lord, only the short point so far the law is concerned, that is regarding the residential certificate. Because the Anganwadi center, is situated, the candidate should be belongs to that area. An outsider, if the non-availability of the candidate from that area, they can also invite the application from the outsider. Here, the present petition, the appellant, so far the appellant is concerned, she belongs to that village, that is Pondua village, and the selected candidate belongs to the outsider. And only the CDPO were interested to give an appointment and give an appointment stating that this is the that is Hamlet village, stating that because the center is situated there. That is the point. Because the advertisement is very clear that we have to produce residential certificate. That is the beneficiary scheme. And residential certificate means the present appellant belongs to the Pondua village, where the Anganwadi center is situated. And the selected candidate does not belong to the Pondua village. That is the point.
No, but Pandua itself has Chari, Varia, Alarpur.
Alarpur, yes. Alarpur having a Anganwadi center is there, where the selected candidate belongs.
All this doesn't call for interference, sir. You say the challenge in the present petition to appeal is to an order dated 14th August 2013 of the learned single judge, dismissing writ petition civil 20395 of 2010, filed by the present appellant. Paragraph. The appellant had questioned the appointment given to opposite party number 4 when she did not belong to the Pandua village, for which the advertisement had been issued for appointment of an Anganwadi worker. Paragraph. The additional district magistrate Cuttack ordered an inquiry and found that Pandua was a hamlet of village Alarpur, and the AWC Pandua consisted of inhabitants of, catered to the needs of inhabitants of Pandua, Chari, Gharia, and Alarpur. Full stop. With the opposite party number 4 being a resident of Alarpur and having secured the highest mark, her appointment was upheld. Paragraph. The impugned order of the learned single judge has proceeded on the basis of the report submitted to the ADM. And that factual finding has not been able to be overcome by the counsel for the appellant, either before the learned single judge or before this court. Full stop. Consequently, the court is not inclined to interfere with the impugned order of the learned single judge. The appeal is dismissed.
Supplementary list, item number 16.
May I be, pardon me, Lord. I had item number 8. I thought the criminal will take some time. So I got item 8.
We wait for the list to get over, sir.
Supplementary list, item number 16.
No, appeal is dismissed, not possible.
Supplementary list item number 17.
17. But I am appearing for the appellant, 17.
Yes.
No, here, the revision under section 37(1) of the Consolidation Act was entertained after 27 years of the publication. Now, admittedly, while the revisional authority was considering the matter, he had not addressed to this point, to this aspect that it was delayed by 27 years. The Honorable Single Judge has relied on the Gulzar Khan's decision, the full-bench decision, but that itself says that it is not a matter of course. 37(1) is not as a matter of course. There has to be circumstances justifying. And I had cited 3 decisions before the Honorable Court where 20 years delay, 13 years delay have been not entertained by this Honorable Court. And one other thing, my main impediment in this decision of the Honorable Single Judge is that I had filed 2 suits after the recording of the consultation. And those 2 suits are pending. The Honorable Single Judge says that those 2 suits are not pending. Non-suited me here itself.
Who's for the other side? You're there.
Please, Millards. Millards, there are 2 IAS Millards listed.
No, the substitution.
No, you are appearing for the Consolidation Commissioner.
Please, Millards, but the
And who's appearing for the private respondents? Gangadhar Panda and Maheshwar Panda. Oh, there are 4 private respondents.
Yes.
Who's appearing for them?
One counsel is appearing, but last time also
the noting says AD not back from respondents.
What's the delay in filing the substitution application? How many days delay?
Substitution, the present substitution.
IA 1892 of 2022
Yes, Lord.
is an application for delay in substitution.
Yes, Lord.
What's the amount of delay, sir? When is the death? Nothing is known, sir. Expired on 18/11/21.
18/11/21.
All right. For the reason stated, the delay is condoned. And 1891 of 2022.
1891, 1890.
Yeah.
All the 3.
For the reason stated, the abatement against the appellant Makanta Panda set aside. He shall stand substituted by the 2 legal representatives shown in the application. The consolidated cost title be filed within a week. Then in 1890, the substitution is allowed as prayed for. The amended cost title be filed within a week. Now, who's appearing for the private respondents?
It is not appearing.
The list, Millards, says there's a noting that AD not back from the respondent. So therefore, Millards, I don't think no one.
No, some London counsel is appearing.
Mr. 99.
Yeah, AD not back. There's no name in the list.
All right, none is appearing for the private response 2 to 4. Fresh notice returnable. 14 November. Interim order continue.
Supplementary list item number 18.
None appears dismissed.
Supplementary list item number 19.
My lord, analogous read appeal were refused, my lord. Your lordship may pass similar order so that. 9. In the meanwhile, my lord, the PF must have been released. All the
In view of the order dated 26th August 2015 in writ appeal 265/2013 bracket, the regional PF commissioner versus Premanand Bhoi and others bracket. The present writ appeal is dismissed.
Supplementary list item number 20.
Say matter, my lord. This was a PIL, my lord. This is a registered judicial suo motu PIL, my lord. Wherein, my lord, the litigation was relating to the water quality of the tributaries to River Brahmani. I am representing the Central Pollution Control Board. We have already submitted, my lord, as per the last order of this honorable court. We have given our reports.
The last order was 28th August 2015.
Yes, my lord.
So what has happened since then? 7 years.
On the last occasion, my lord, the order of this honorable court was to implement the recommendations made by the Central Pollution Control Board, my lord. On behalf of the Central Pollution Control Board, a sealed cover report was submitted before this honorable court, my lord.
But after that, they were asked to take due note of the suggestions, recommendations, and initiate urgent steps.
I am appealing for the state pollution control. On the basis of suggestions, steps taken, I have filed an affidavit. That was 8 years back. I will have to take instruction what in the meantime, what follow-up actions have been taken.
The concern in the present petition is regarding the pollution caused to River Brahmani and its tributaries. Reports have been called for from the Central Pollution Control Board. Full stop. That report was submitted, and after perusing the report, this court, by an order dated 28th August 2015, directed the Chief Secretary, Government of Orissa, to take due note of the suggestions of the recommendations of the CPCB.
My lord, there is a affidavit of Chief Secretary dated 13/11/2015.
2015? No, so they have to be after that, no? Because there is a to make River Brahmani and its major tributaries pollution-free paragraph. Pursuant thereto, an affidavit has been filed on 13th November
2015
by the Chief Secretary. Claiming that steps had in fact been taken by the state government pursuant to the recommendations of the CPCB and the SPCB paragraph. Since more than 7 years have elapsed since then, the court would like the state government to file a further affidavit stating whether the recommendations of the CPCB and SPCB are still being implemented, and that the water quality of the Brahmani River and the tributaries and its tributaries are at the acceptable level. The affidavit will be filed at least 2 weeks prior to the next date. List on 16th November.
Supplementary list item number 21.
None appears to for no opposition.
Evrod is for cases, not this one. This
Petition was registered on the basis of a letter written by some students of Ravenshaw University regarding the seepage of waters from the roofs of the classrooms. Full stop. A series of directions have been issued by this court from time to time. By the order dated 5th August 2014, this court had directed the chief engineer to renovate the electrical wiring with good quality insulation, and for the registrar of the Ravenshaw University to cooperate, to extend all cooperation to the Secretary Works Department, as well as the Chief Engineer GED. Paragraph. On 21st November 2014, after perusal of the affidavit filed on behalf of the university, it was observed that repair works of the classrooms of the physics department, the corridors of the chemistry and physics department, and one of the rooms occupied by the chairman of the Council of Deans had not yet started. Full stop. Adjourning the case by 6 weeks, it was expected that the university would come in coordination with the state government, ensure that all repair works found necessary are complete. Paragraph. Thereafter, there's been no substantive hearing of the case. So, in other words, it's not known whether in the past nearly 8 years after the passing of the order dated 21st November 2014, the entire repair work as envisaged that it has been completed. The court accordingly directs that a fresh affidavit be filed on behalf of the Ravenshaw University through its registrar, confirming that the earlier directions issued by this court on repair works to the various departments has actually been carried out. The affidavit will be filed at least 1 week prior to the next date. List on 23rd November.
My lord, this order may be communicated to the registrar because they have got
a copy of this order
panel of lawyers
to the registrar Ravenshaw University forthwith.
for compliance.
For compliance, yeah.
Supplementary list item number 22.
Item 22, your lordship, became infectious, your lordship.
Infectious disposed of.
Supplementary item 23.
Item 23 not received.
Not pressed. All right. Dismissed is not pressed.
Supplementary list item 24.
Copy of counter has not been received, man.
Oh, okay.
The
No
PL
instructions
matter, man.
received.
Copy of
Dismissed.
counter has not been received.
No. What is the matter about?
Man, they have to provide the snake and dog bite injections to the CSC in Isnukoi. Are not available there. People are safely approached the said CSC. There are thousands people are depending upon the said CSC as because it is the existence of the CSC which is near the Kotok or Chandbal main road, man. Therefore, people are safely approached this CSC. And then not available when any snake bite or dog bite injections.
That was the status of 2015. In the meanwhile, there are lot of progresses in all medical facilities. Government is upgrading all the CHCs. And I know Nischint Kohli CHC has also been upgraded. So he must take the latest instruction. These are all available there. That is your lordship may direct me to, if...
There's already a counter filed.
Yes, already counter filed. That is in the year 2015. Showing the stock register, everything. There is another CHC near Nischint Kohli, that is Mahanga CHC.
Well, Mahanga CHC, there are the in the interior area, minor.
So we need to know the current position. This is all 2015. You have not brought up the matter of hearing after that.
That is what I'm saying.
You see, the petition complains of non-availability. This petition filed way back in 2015, complaint of non-availability of adequate medicines, adequate quantity of medicines to treat snake bites, dog bites, and rabies. Full stop. A counter affidavit was filed
on 21st July 2015.
On 21st July 2015. Claiming that victims of snake bites were always well attended and provided appropriate treatment. And there is reference made to the SCP Medical College, depending on the seriousness of the patient.
The stock register is at Annexure A by 3. We have annexed the stock register.
Yeah, copies of the stock register have been enclosed as Annexure A3 to the affidavit. Full stop. Paragraph, it is not clear if the problem still persists. Full stop. Therefore, leaving it open to the petitioner to approach the court in case, even as of today. No, to first file a representation to the opposite parties, and then in regard to non-availability, if any, of the drugs, anti-snake venom drugs, and after following up on such representation, to seek appropriate remedies in accordance with law. The petition is disposed of the matters.
Supplementary list item 25.
None appears dismissed from opposition.
Supplementary item 26.
None appears dismissed from opposition.
Supplementary list item number 27.
My lord, item 26, I am for the opposite part number 2. My presence may be noted, my lord.
All right.
Item number 27.
Your lordship, in item 27, the matter has become infructuous, your lordship.
All right. Petition has become infructuous. This is post of such.
Supplementary list item 8.
May it please, your lordship. And the matter is that in 2014, the state of Odisha and Department of Employment and Technical Education and Training published an advertisement for a special recruitment drive. The drive was to drive a special recruitment drive for passed out students of Odisha in engineering, MBA, MC and pharmacy in collaboration with BPUT Odisha. The said drive was scheduled that in the said drive, the various companies and industries were scheduled to participate, and the exercise was to be taken in between 17 September to 20 September 2014. However, after that, a notice was again issued that the said drive has been postponed to after Diwali. After Diwali, when thousands of students from all over Odisha had applied for this special recruitment drive, After Diwali, when the students are trying to log into this website, the website is also not there in the internet. They have charged 100 rupees per application, my lord. And till today, also notice was issued in the said matter.
No, what do you want? It's a 2014 selection, sir. We are in 2022.
My lord, till date, pursuant to that advertisement, no special recruitment drive has been undertaken. And also they have, this is the money that they have 100 rupees per the application.
What is 100 rupees, sir? Nothing.
My lord, thousands of students have applied.
So what? For each of them, returning 100 rupees is going to be a humongous task. You'll end up spending more than 100 rupees
at least,
just to distribute that 100 rupees.
Statement.
These are not matters of BIL, sir. These are not matters of BIL.
But my lord, if thousands of students for 100 rupees, it is an unjust enrichment. At least
no, nothing called unjust enrichment here, please. Sorry. You see, the petition seeks refund of the application fee collected by the state government from applicants pursuant to a special recruitment drive of 2014, which ultimately came to be cancelled with no recruitment taking place. Paragraph. The present petition has been pending since 2015. It is not, the court is not persuaded to hold that collecting rupees 100 from each of the applicants towards the recruitment drive by the government is an unreasonable exercise, considering that a lot of arrangements have indeed to be put in place for such a special recruitment drive. Full stop. It would not be practical for the government to be ordered at this stage, more than 7 years after the said recruitment drive, to locate each of the applicants to refund the application fee collected. Full stop. Sheer impracticality that exercise and the expenditure it would involve, which would be far more than rupees 100 collected from each student, does not persuade this court to issue a mandamus in that regard. Petition is accordingly disposed of.
Supplementary list item 29.
None appears dismissed.
Supplementary list item number 30.
My lord, this is for the protection of elephants, the forest, and the persons.
We're already dealing with that matter, right?
My lord,
25th, on 25th.
that's coming up on 25th. All these matters can be tagged.
Correct.
Competing.
My lord, this may be also added to that.
Yeah. List on 25th August, along with
WPC 14,706 of 2022.
all right, 14,706 of 2022. All right.
My lord, may I have your lordship's indulgence in drawing attention to another fact which may be related to this. It's that in the last 7 years, wild boar has become a very great issue for livelihood, challenging the livelihood of farmers.
Right.
So therefore, my lords, in the Wildlife Act, wild boar is part of Schedule 3. But fortunately, there is a section in Wildlife Act which says that hunting of wildlife be permitted in certain cases. In this case, wildlife comes under Schedule 3, where it is said that the chief wildlife warden or the authorized officer, if he is satisfied that any wild animal specified in Schedule 2 and Schedule 3, in this case, it is specified in Schedule 3, has become dangerous to human life or to property, including standing crops on any land, or is so disabled or diseased as to be beyond recovery, by order in writing and stating the reasons therefore, permit any person to hunt such animals specified, such animals or group of animals in that specified area to be hunted. So this is an occasion or opportunity for the farmers to handle the menace.
No, that could be additional problems. You see, the problem is if you arm the villagers, they can end up using it against all kinds of animals. That's how the elephants are found. There's a lot of bullet marks,
Yes,
pellet
madam.
marks.
This is
Again,
specified,
Arms Act provision will be applicable
this is
to them.
specified only
is-
to wild boars.
No,
in
but
Schedule
you
3.
can't tell the villager you have to use this only for a wild boar and not against somebody, some other animal.
No.
So this is the problem. Once you legalize the provision of arms to villagers,
Yes, ma'am.
you can't control how they will start using it.
Yeah, but it is part of a statute, my lords.
No, it is. But how should it be put into operation is a big
yes,
challenge.
If the task force could be
So we have to file that's why we ask for
also.
My lord, for the knowledge of this honorable court, in the meanwhile, there is a high level committee chaired by chaired by the chief secretary, and there is some points have been formulated. We will present it on 25th.
All right.
How to deal with all this?
In the third matter, there's
Also, this issue may be also dealt with by them.
Yes, yes.
in the
Obviously.
third matter, there's a convenience note where we have drawn the attention of the court to certain NGT orders for notifying 14 elephant corridors. If those corridors are notified, then some of the problems will be.
Those are notified.
Those are notified.
I propose other things also, how they will not be destroyed by other elements like the railway, etc. That your lordship to hear and decide the matter.
Yes. All right.
Elephants are to live. They are to survive, not human well alone.
All right.
Supplementary list item number 31.
May I please, Lord? Ma'am, I'm permitted to do the next on BC matter. This is the matter related to Konark temple and Sri Jagannath temple repair matter, madam. And the last order, my lord, 17/12/2019. You can glance over the order, madam. In spite of the suggestion put for by amicus curiae, the local officer.
This is the Puri temple we've dealt with. Is already
My lord, it's a case of Puri temple where the repair and maintenance of Puri temple is concerned, which has been disposed of by the Supreme Court. It was a project work.
These
But
particular
it's
issues are already dealt with in many cases by honorable apex court even.
My lord, this has not been attended till date. And the lot of work is yet to be done.
It is going on day-to-day basis.
Every
ASI is doing.
Let me be permitted to tell. Every day you will see that there is a need in the Puri temple. Either this one Rathamandar is collapsed or till today, from 2018 August, nothing has been done in Rathamandar, which in the position, my lord. Nothing has been done. And
Yes.
2.5 years have passed.
Yes, sir.
When pandemic is there, I am not able to go there. Next to Konark. So in Konark, they have given a false affidavit.
May I clarify, my lord?
They agreed on this.
Sir,
May I permit to submit, my lord?
Sir, 1 minute. This petition has nothing to do with Konarak.
Both. No. Second,
Both are different sort of act.
Analogous matter, 2 minutes.
Dilip Kumar Mahapatra.
Abhishek Das is Puri, I think.
Yes.
You are appearing for the petitioners in both.
I am amicus curiae.
I am looking to the both petitioners.
So where is some empirical data, some statistics? Where do you have that, sir?
I will give after because it has come after 2.5 years. I will give after 10 days time. I will give the 10 days time. I will give.
All right.
Yes, my lord, just here 2 minutes. In Konark, they have given an affidavit which I do not agree. And the then Chief Justice has asked the Cultural Secretary, Government of India to attend. And on that, there was a seminar on 2nd of February 2020. On seminar, it has been decided what I have told is correct, what they have told is wrong. Till today, nothing has been done. Even the proceeding, they have come out with the proceeding, nothing has been mentioned.
So what directions do you want? You'll have to be specific. What are the kind of directions you want from the court?
Lord, they do work repair of Puri.
We simply
is to be done.
We'll just in one line say, tell them, yes, repair Puri temple. That's a disposal condition. We say repair Puri temple and dispose it off.
It cannot be disposed. Simply say repair for the temple. That's all I have to say. Nothing else. Only the temple. I'm sorry, we don't agree with you. But simply some repair for the temple. What are they supposed to do? A lot of work is to be done. So unless you simply telling them repair, on Dr. Kindly try and understand. You are an amicus curiae, you have to assist the court. Yes, unless don't give submissions like give them one line direction saying repair for my lord. That's direction. You see very strongly. The things we have to give directions which are practical and implementable. I will give you after time. It's not, but you are saying simply saying things. Not impractical. My lord, impractical. My lord, I am telling you, there is a meeting. We can't see. This is becoming like a lecture, sir. I'm sorry to say this. My lord, you don't even know. You're saying my assistance to the court. Kindly realize that. That understood, man. And this is serious business, sir. We take this issue very seriously. If we are giving directions, it has to be meaningful and it should be capable of being implemented. Yes, ma'am. You are only getting emotional and simply saying, serve the temple, repair the temple, has no meaning. My lord, after 2.5 years, I am not with facts, with the proper note. I am asking us where specific directions are needed, then we can issue those directions. My lord, give me 7 days time, I will give you details. Details about Puri temple as well as Quran.
One thing I must bring to your lordship's attention. My learned senior friend is saying that for last 2.5 years, I have not visited this spot, but many things he is arguing, like petitioner. He is an amicus curiae. He should come forward with a convenience note. What are the difficulties? He should.
So first, you undertake a visit. You please personally visit. I personally visit both these places. You make a note of what is to be done. You get assistance from the local administration. What we have done, brief me. Let them brief you what has happened. My lord, because my wife has died, I am not permitted to go to the temple. That's why I am not going. So without going, how are you making all the questions?
How you are saying?
Because I'm not very unfortunate. Now it transpires that without even going to the place, you're making all these elements. Not at all. I will stand by that. Whatever the proceedings have been done, nothing has been done. Nothing has been done. I will do details by now. What when visiting the place, how do you make these statements? My lord, I'm telling you, I will inquire it. I will inquire from the entities, not that I'm telling you authority. Which authority? I have talked to the ASI people. I have talked. ASI is not the only person doing it. No, the ASI is only repairman. Nothing. Nobody can go except the ASI. So ASI has told you they've done nothing. Only ASI should repair me. No, ASI told you they've done nothing. They have not done. They have not done. ASI has told you. Yes. Who in the ASI has told you? Yes, I discussed that even the advocate. No, this is not. Let us be serious about these things, sir. I'm sorry, you have to be much more serious about this. Talking to an ASI advocate is not the same thing as talking to ASI. I have talked to the circle. I have talked to the circle.
He is forgetting that he is an amicus curiae.
Gather your thoughts properly and address us. So you're addressing a court. You please be, and you're an amicus curiae.
You're not supposed to be going on arguing with us. Somehow I'm getting the feeling, sir, I'm being very honest with you. I'm sorry, I'm being very honest with you. We'll pass it over. You please gather your thoughts, come back and make submissions. So pass over. Pass over.
Let me give 7 days time, my lord.
Sir, we are passing it over. You please gather your thoughts, what you want to say, and then you make submissions before us. All right.
All right.
Pass over. Pass over.
Okay.
Supplementary list item number 32.
May I please, my lord? My lord, for the interest of the lawyers and for the interest of the institution, this PL has been filed and being prima facie satisfied, your lordships please to pass interim orders restricting the media house to stop the report. Now, my lord, it is up to your lordships to decide.
No, what does it mean, sir? What is this? What is
the fact is that there is an alleged occurrence of molestation of a crime branch woman inspector by 2 government advocates inside the lift of the High Court premises.
Sir, all that is over long ago.
Yes, that's why
the passage of time, the facts spoke, the issues raised in the present petition.
I am in the tag.
Do not survive for consideration. The petition having become infructuous, it is disposed of. All right.
Supplementary list item number 33.
33, my lord. So there is a bereavement in my family, my lord. So I pray your lordship may take it up next week, my lord.
Please tell us what the matter is about, sir.
I am appearing for the contesting opposite party number 2, my lord.
Let us see who's for the petitioner. Let us find out what the petition is about.
I'm for the petitioner. I'm in VC, my lord.
Yes.
I have no instruction in the matter.
Counsel, the petitioner states he has no instructions. The petition is disposed of. All right.
The connected matters are there, your lordship. There is contract matter. We'll take it next week.
No, tell us what it is.
Your lordship, this is regarding, my lords may kindly take up the date chart that I have filed.
No, is it a PIL now? This is
PIL.
So list before the concerned bench. This writ petition civil 13597, 32597, 13260. List before the appropriate bench on 28th November.
28th November.
Supplementary list item number 34. Item 34.
Mahanagar minority.
Item number 34, they have not supplied us any counter copy.
So who is for the petitioner? You first tell us. Who's for the petitioner? Is anyone appearing for the petitioner? Kindly speak into the mic, madam.
That's why I'm appearing for the petitioner.
Kindly tell us what the petition is about.
Actually, I have much knowledge about this.
No, I'm sorry. You'll have to.
Lordship, he is in a different court. One matter is going on.
Sorry?
My senior is in different other courts.
Pass over. All right, pass over.
Supplementary list item 35.
My lord, this litigation is involving a illegal operation of stone quarry. And the government has already filed the counter and I have filed the rejoinder also. In their counter, they have totally denied our contention, and RI has reported by affixing to signature of 2 persons and denied that there is no such illegal operation is going on. I have filed rejoinder, they're annexing 2 affidavit of 2 persons, those who have affixing the signature in the report of RI, and also annexed of some photographs, which is clearly showing that there is illegal operation, operation has already been done. But RI report is saying that there is not at all operation has at all done. And fact is that the leaseholder has not operated the person which has been given to lease him. He has operated the other plots, over which the stone quarry is situated, madam. The given plot is also our objection that this is a holy place, but government has declared it is a declared source and given lease to the opposite party number 5. But practically he has not done his excavation over that plot. He has excavated in the other plot, which are situated near the given plot. This is our.
And the lease period of the lessee has already been
but
over.
He has.
Then what's the point now?
But he has illegally operated. His action should be taken against the such wrongdoer manner. This is the my prayer.
But it's all disputed questions of fact. And who is the person who has done it? Opposite party number 5.
He is appearing through a lawyer. He has filed a counter affidavit also. Samir Kumar Satpathy. I'm sorry. No. I'm very sorry.
Gauri Shankar Behra.
Gauri Shankar Behra.
I don't think he has filed an affidavit.
No. I'm very sorry. He has not filed. But the lease deed at page 11 reveals that the lease period expires in March 2022.
That's over already.
And that is not the question here in the, your lordship should decide if someone has given excavator in a.
No, but what does he say? Has he been served? This opposite party number 5.
Yes, notice has been served to him.
No.
He has not.
Is anyone appearing on his behalf?
RI has come forward to protect him.
Is anyone appearing on behalf of opposite party number 5?
No, so far is my.
All your allegation is against him, correct?
Yes.
But
so without supporting him, government is encouraging him, man. That is the.
Madam, without hearing opposite party number 5, you want to say us to say everything against him.
Let him wait. When he will come.
Not even issued to him. So what is this? And the lease is itself over.
Lease period is already over. He is no more in the.
No notice was issued in all these years. In the entire period, no notice has gone to opposite party number 5.
His allegation is that
the main allegation, this writ petition, is about opposite party number 5 operating a stone quarry illegally. That is by mining areas around the area for which he was granted the lease. Full stop. The lease period itself has come to an end in March 2022. Full stop. In the long period during which the writ petition, during the period in which the writ petition was pending, no notice has been issued to opposite party number 5. Full stop. Therefore, he has not had any opportunity of even defending himself in the writ petition. Paragraph. As regards the allegations of the petitioner, the counter affidavit of the Tahsildar of the concerned area has denied all the allegations. Full stop. This, of course, has been refuted by the petitioner by filing a rejoinder. Full stop. Therefore, whether in fact there has been any violation of the conditions of lease is itself a disputed question of fact. Paragraph. With no notice having gone to opposite party number 5 thus far and with the lease having come to an end, the court is not in the above circumstances inclined to interfere at this stage. The petition is accordingly dismissed.
Supplementary list item number 36.
Is a PIM. So much of PIM.
Only so much of some.
Compensation
The detailed order. 4 lakhs. Whom are you appearing for, Mr. Mantri?
My lord, in this case, 11 people died in the.
No, whom are you appearing for?
I am appearing for the South Co. Now which is taken over by Tata Power with the Gridco, and that is TPSODL. And in the meanwhile, the development is that the 11 persons, my lord, they have been paid.
That's it. That is there in the order.
Yes.
4th March order.
6 lakhs each of them have been paid.
6 lakhs.
And 75,000 per injury for each injured person.
No, 4 lakhs has been paid.
4 lakhs.
And 25,000 towards.
No, my lord. That time, my lordship, 2 lakhs was paid by South Co. 2 lakhs by the state government. And also central government has also paid 2 lakhs. This is case is also pending in the OHRC. Case number 419 of 20.
I see.
That is also they are regulating, and they are claiming for
What's the number in the OHRC?
That is 419 of 20.
I see. The arising out of the same incident for which the present petition was registered as a PIL. There appears to be a case pending in the Human Rights Commission, being case number
419 of 20.
419 of 2020. The court is further informed that compensation sum of rupees 6 lakhs has been paid to the legal heirs of the deceased persons. Apart from money for the medical treatment of the injured persons. Considering that the matter is already pending the OHRC, the court does not consider it appropriate to continue with the present petition, and it is disposed of as such.
Supplementary list item 37. Item 37.
Well, another case is WPC 6063 of 2020. That is concerning to other area. NESCO, which has become TPNODL. They have nothing with this matter, but they were also given notice, and that case, well, nothing is there. That may be disposed of also. WPC number 6063 of 20.
So that is then how can
Sorry.
That is the matter listed.
In same case, both are noticed.
Well, it's item 37. As a suo motu writ petition. Pursuant to a news report in
Everything all based on newspapers.
Pursuant to a news report which said that there were certain equipments in government medical colleges which were not functioning.
Actually, we are already dealing with another.
Yes, please, Milad. And this is 2020, Milads. All the government hospitals had filed thereafter comprehensive affidavits giving the status of the equipments, whether the maintenance is being done, which agencies.
The subject matter of the present petition is already being dealt with by this court in other PILs which are pending. So there is no need to multiply the PILs on this aspect. Accordingly, the petition is disposed of.
Item 38.
38, my lord, the matter has become infructuous. I am in virtual mode, my lord. The matter has become infructuous. PIL at that point of time.
All right, sir. No, all right, sir. Counsel, the petitioner states that the petition open-ended infructuous is disposed of as such.
Supplementary item 39.
39, the appointment of chairman and the member secretary of pollution board. I am received the counter copy 1 week time for filing rejoinder.
Perhaps they are already appointed, I think.
What is 39?
39.
No, he's for the petitioner. Yes. What is the matter about, sir?
Matter relating to appointment of chairman and member secretary of state pollution board.
Is the matter still alive?
I think they are already appointed.
Yeah, they must already be in position, sir. You're not even aware if they've been appointed or not.
I am received counter or rejoinder file.
No. Subject of counter rejoinder, sir. Have they been appointed or not? You're not even aware if there is today a chairman or member of the pollution control board. You're not even aware of that. You have filed a petition about that.
I am appearing for the state pollution control.
already number 17 chairman are there. But here, my lord, the issue has been raised whether it pertains to the section for.
No, he's asking for appointment, sir. Have you seen the prayer?
My lord, yes. So in pursuance to the appointment, in pursuance to the 4.2 of the Water Act, 4.2 of the Water Act and 5.2 of the Air Act. That is the prayer.
So far as the prayer is concerned, it is already compliant. That is what.
You are for the pollution control board, no?
No, my lord.
Is this prayer allowed or not?
No more allowed. So far the appointment is there.
That is what.
Then
Violation of Honorable Supreme Court direction in civil appeal number 13559/2017.
Sir, you had filed a petition at the time when there was no chairman and secretary. Now there is a chairman and secretary.
Immediate steps for appointment of sorts.
Yeah, with the chairman and member secretary of the State Pollution Control Board already being in position. The prayer in the present petition does not survive. It is disposed of as such.
Supplementary list item number 40. Item number 40.
None appears to for some observation.
Supplementary item 41.
None appears to for some observation.
Supplementary list item 42.
In 42, initially my prayer was to provide a road, construction of a road in Gangwa River embankment after removing the encroachments. There has been some development in the meanwhile. Your Lordship may dispose of the matter.
All right. Counsel, the petitioner states due to subsequent developments, the petition has been rendered infructuous. It is disposed of as such.
Supplementary list item number 43.
None appears to for some opposition.
Supplementary list item 44.
None appears to for some opposition.
Supplementary list item number 45.
None appears to for some opposition.
Supplementary list item number 46.
May I please, Your Lord?
Yes.
That's not.
What's the delay, sir?
There is no delay because this is during the COVID period. Honorable Single Judge order dated 16th April to 2021. It was filed on 9th February 2022.
I think we passed similar orders in so many matters.
Yes, ma'am.
Where is that? Who's appearing for the other side?
No one is appearing. Mr. P.K. Raut was appearing before Honorable Single Judge. His name appears.
373, IA 373 for the reason stated, the delay in filing the writ appeal is condoned. The IA is disposed of. All right, you say that there is no delay and therefore it's disposed of. The writ appeal, you say notice be served through counsel who appeared for the respondent before the single judge. Returnable to 10th October. There shall be stay of the impugned order in the meanwhile.
Supplementary item 47.
Item 47, may I pray Your Lordship may take it up tomorrow?
All right, list tomorrow.
Supplementary list item 48.
And please, Your Lordship.
48.
My responsibility is due diligence, my lord. Here the annexure 4, my lord, Roman page 17.
There are so many defects, sir.
I undertake to.
All right, counsel for the petitioner states that he remove the defects within a week, risk thereafter.
Supplementary list for orders item 49.
Your Lordship, I am for the opposite party.
All right.
My lord. And for that reason, Your Lordship, last 10 years, this case is pending, order is not being implemented on the ground, that review is pending. On my memo, this has been listed.
None appears for the review petitioner. The review petition is dismissed, the interim order is vacated.
No interim order was there. Only filing the review petition and thereafter taking the plea.
All right. The review petitions are dismissed. What of the contempt case?
Contempt, Your Lordship, now the contempt will be implemented because of that plea taken, that as the order is under challenge in the review petition, for that reason we are not implementing the order. Your Lordship may simply say the order be implemented as the review petition has been dismissed.
All right. Now that the review petitions have been dismissed, the order in question the implemented fourth.
Oh, right, you're right. Supplementary list item number 50.
May I please, your lordship? I am in VC, my lord. I am in VC, my lord.
Yes.
My lord, this writ appeal has been preferred against the order of Honorable Single Judge, my lord. Here, my lord, the petitioner was the fact of, there has been delay of 106 days in filing the writ appeal, my lord. The notice has been issued. Opposite party has appeared, my lord.
Yes, you are there for the opposite.
There is a 160 delay, and each day of the delay has to be explained. But in this case, they have not explained the delay. So, in view of the Honorable Appeals Court decision, I have mentioned.
What's the reason for the delay, sir?
My lord, here the judgment was order was passed on 9/2/2021, my lord. Same was sent to the headquarters for necessary action, my lord. Thereafter, legal opinion was brought from the law ministry, my lord. Thereafter it was filed.
That is usually not accepted, sir. You have to give a detailed breakup of the delay. And even that, if it's only for administrative reasons, the Supreme Court says it should not be condoned.
Yes, my lord. But here the question is, my lord, in the 9/2/2021, since there was COVID period, my lord, at that time, therefore there was some communication gap between the department and with the council, my lord. Therefore, there has been delay of 106 days, my lord.
Oh, so COVID period, sir.
But that period, they have not taken in the delay period, sir.
No. Supreme Court orders are there on this COVID period.
And another thing is that this is expected inquiry, my lord. The petitioner has not given opportunity.
Yes, that is merit of the case. I will
come to a minute. So, as far as the delay is concerned, it appears that the delays occurred during the period of COVID-19. In that view of the matter, the application is allowed and the delay in filing the appeal is condoned. Now come to the main matter, sir.
My lord. Here, my lord, the petitioner, the opposite party, I mean the respondent in the writ appeal, my lord, he has filed the writ application against the order of dismissal, as well as the dismissal order was confirmed by the appellate authority as well as the revisional authority, my lord. Here, what has happened, my lord? He was granted leave for 15 days from 1/2/97, from 13/1/97 to 1/2/97, my lord. Thereafter, he didn't join, for which the proceeding under section under Rule 34 of CISF rules was initiated, and that was on 1/12/2/97. Inquiry was conducted. He was noticed, my lord. Though he has received the notice, he didn't appear and didn't cooperate with the proceeding, my lord. Finally, on 14/5/1998, he was dismissed from service. Thereafter, my lord, in the year 2006, that is on 1/6/2006, he has filed appeal before London DIG after gap of 8 years, my lord, on the ground that he was ill and he was undergoing treatment before the hospital at Ranchi. Well, but in that appeal, he was only given 3 certificates. Your lordship may turn to where he has only stated 3 documents, that is a 21/1/97, 4/5/97. Thereafter, on 18/4/2006, he was prescribed by the doctor to take 3 to 4 months rates. No explanation was given why he has not filed the appeal within time. Thereafter, after 8 years, he has filed the appeal. Therefore, the appeal was dismissed for delay. Against that, he has preferred revision, and revision petition was also dismissed. Against that, he has preferred the writ application.
Is there any contempt petition pending?
No, my lord. There is no contempt petition.
All right. We'll just say in the writ appeal, you say notice, he accepts notice. Is the entire writ record available here?
Yes, my lord. That is annexed along with the writ appeal.
All right. Since the entire writ petition record is available, list for final hearing on 5th December.
Supplementary list for orders item number 51.
The order of Honorable Single Judge may be stayed, ma'am.
There is no contempt, you said, sir. So why should we stay it now?
Obliged.
Item 51.
The lordship adjournment.
Listing it for final hearing. We issued notice to you. You have accepted notice in the writ appeal. You listed it for final hearing.
5th December. Item 51.
51, application for bail in the criminal appeal, your lordship. Application for bail in criminal appeal, your lordship.
there are two appellants. Appellant number 1 is father and 2 is the son. They are inside custody near about 10 years, Your Lordship. Exactly the date from their inside custody is, Your Lordship, is 14/11/2013, Your Lordship. The allegation is that there is some civil dispute. The deceased is the brother of the appellant number 1. They were traveling in a boat, and allegation is that first the father assaulted in a bhujali, and after that the son assaulted the deceased with a bhujali. For that he fell down in the river and died. That's the allegation. If Your Lordship will see, there are a number of eyewitnesses to the occurrence. There 1, 8, 9, 10, 14 and 15 are the eyewitnesses to the occurrence, Your Lordship. And all of them categorically stated that the son assaulted on the head. Your Lordship, 3 to 4 blows on the head. And the doctor opined that there are 4 injuries. 1 is on the neck and other 3 on the head, and for which the brain matter comes out, and he died. So I pray, at least considering the fact that they are inside custody for 10 years, let's say
consider paper book ready, we'll hear the appeal itself. We'll hear the appeal itself. You say, well, the court is not inclined to entertain the plea for bail at this stage. It is directed that the paper books of the appeal be prepared within 4 weeks and supplied to counsel for the parties. The appeal be set down for final hearing on 13th October.
Supplementary list item number 52.
So this 142 of 2016 is accordingly dismissed.
No, on behalf of Mr. Dipali Mahapatra, she has not filed this appeal, madam, as per the instruction.
She has not filed this appeal.
No, my lord, but his power is there. Her power is there. Therefore, he has directed me to tell that I have not filed this appeal.
What does it mean? The Vakalatnama is there. How can she say she's not filed it?
Some other powers is there, my lord.
No. Her submission is there. Just see the 12th April 2015 order. You showed me the 12th April 2015 order. It appeared bail has been granted.
Will it 5/7 if illogical pages 5/7/2022? Order dated 5/7/2022.
Only then.
There was probably a prisoner petition, my lord.
In place of. So who's this Amulya Ratan Panda? Who's Amulya Ratna Panda?
He is a regular in criminal matters.
We'll just pass it over. Just ask him to remain present. He'll pass over.
Supplementary list item number 53.
53, I have filed Bhoklatram on 20th July, Your Lordship. That has not been in the record with the prisoner personal lordship. And I have filed an IA for interim bail, Your Lordship, that is 1/266 of 22. That is on board today, Your Lordship. Lordship may direct the State Council to take instruction on the papers, annexed medical papers. The wife of the petitioner appellant is seriously ill and bedridden, Your Lordship.
All right. In IA 1266 of 2022 notice, Ms. Patnaik accepts notice and seeks time for instructions.
Replacement.
My name be deleted from the list. Since another advertisement filed by prisoner petition, my name be deleted.
Mr.
J.K. Ponda, the name of J.K. Ponda is deleted from the
You are appearing in that earlier matter also, sir? No, that is Amol Ratna Panda.
It's Ratna Panda.
Sorry. All right. In this matter, you say the name of Mr. A.K. Panda be deleted.
My name
and the name of?
S.K. Sushant Kumar.
My name is J.K. Panda, Jugal Kishore Panda.
J.K. Panda be deleted and
Sushant Kumar Baral LLC and Associates.
Or Mr. S.K. Baral and Associates, namely indicated for the appeal.
Your Lordship is fixing a date, ma'am?
Next Monday.
Obliged.
Obliged.
Supplementary list item 54.
May it please your lordship, my lord. My lord, so far appeal is concerned, the appeal being admitted, my lord, the bail application is pending for adjudication. My responsibility with the due diligence, my lord. So far the judgment passed by the learned additional sessions of Nimapada, my lord. Initially the case was charge sheeted under section 498 and 302 IPC, my lord. And the learned session judge awarded punishment for life imprisonment and also awarded a fine rupees 5,000. In default, 6-month imprisonment also there too, my lord. My response submission, so far the allegation is concerned, accused is in custody, my lord, with effect from my lord, 10th of March 2015, my lord, completing more than 7 years, my lord. And the allegation internally contended that the sole accused committed murder of his wife, my lord, by means of a knife, my lord. And the further allegation that there was not a pool of blood murder case, my lord. And it was a sudden provocation, my lord, and a sudden quarrel, my lord. And because, my lord, so far the prosecution story is concerned, my lord, my response submission on 18 March 2015 at night, my lord, the accused persons as well as his wife and one son, my lord, Dibyanshu, they have attended fathering the house in dinner, my lord. Soon after completion of the dinner, my lord, they came to their residential house, and on the residential house at night, my lord, it was alleged that the wife Lakshmipriya of the sole accused was also murdered, my lord, by means of a knife, my lords. And when there is a series of contradiction, my lord, with humble submission, when there is a series of contradiction, and when the case is purely based on, my lord, under section 3042, my lord, the law and the additional session judge inter alia hold the conviction under section 302, my lord. And with due diligence, my lord, I was granted parole, my lord, for a period of 15 days on the eve of to attend my option ceremony of my mother, my lord. And also being released, I also duly surrender before the
paperwork is here. If you're ready to argue now, we'll hear you now.
So, my lord, my humble submission, my lord.
We are prepared to hear the appeal right now, sir.
I responsible my bail.
Paperwork is ready. You seem to be fully ready with the matter. The way you are arguing are so fully ready. Why don't you start arguing the appeal itself?
My lord, I humbly submit, my lord, my bail application might be disposed of, my lord.
Better still, sir, your appeal itself will be heard right now.
Oblige, my lord.
My
response submission, my lord.
Yes.
So far, trial is concerned, my lord. As per the judgment passed by the learned additional session judge, my lord, is perverse and erroneous one.
Right.
Only strengthen the argument on the 3 grounds, my lord.
Right.
My first submission before this annual court is, though there was not a cool blood murder case, and there was a sudden quarrel existed among the wife and husband, my lord, on the alleged occurrence, that is 8 March 2015, my lord. So the case is squarely based on under section 304 part 2, my lord. With the Lord trial court internally hold the conviction under section 302, my lord. However, before the trial court, my lord, there was 30 witnesses. So far the charge sheet is concerned, my lord. Among 30 witnesses, only 27 witnesses examined and cross-examined before the trial court, my lord. And so far the FIR is concerned, my lord. My response submission, FIR was lodged by the PW number 10, happens to be fathering of the my lord sole accused, and my lord, so far the FIR is concerned, my lord. The FIR was written, my lord, by the PW number 2, my lord. PW number 2 happens to be daughter of the PW number 10, that is the Bijay Kumar Das, my lord. My responsibility, so far the FIR is concerned, my lord. The law is settled to express that when the authorship of the FIR is remained doubtful, the entire prosecution case is doubtful one. Because so far the FIR is concerned, my lord. The endorsement of the FIR was not reasonable and explained to the informant, my lord. That is sole drawback, my lord. So far trial is concerned. The endorsement of the FIR was not read over. The contents of the FIR was not read over and explained to the informant, my lord. That is the first drawback, my lord. And then my response on this one. So far the case is concerned, my lord, it was alleged that the accused committed murder of his wife, but my responsibility. It is a fact that some witnesses they have stated the cause of death, though was also short and hemorrhage, my lord. The cause of death was by means of a knife. But so far as period number 2, period number 3, and period number 10, all are concerned, they inter alia contended that the cause of death not by means of a knife, but by means of a chapod, my lord. And so far the weapon, which is differ from that is knife to chapod, also, my lord, not considered by the trial court, my lord. This is my second submission before the honorable court, my lord. And so far as case is concerned, my lord, the PW number 4 happens to be only son of the, my lord, accused as well as this is Lakshmipriya. He also deposed his statement before the London trial court at the age of 80, my lord. And when the occurrence was taken place on 8 March 2015, by the time PW number 4, Divyanshu age was only 7 years. And so far oath act is concerned, my lord. As per oath act, a person's not below, not above the age of 12, my lords, have no right to also adduce his evidence before the trial court. And so far the oath act is concerned, my lord. When the oath act was presented before the London trial court also did not consider and accepted the evidence of the PW number 4 happens to be only some Divyanshu of the my lord accused. That is also another drawback. And my submission before this honorable court is, please make a glance. Sorry. My lord, my response submission before this honorable court is, my lord, please make a glance. That is the Vidula Das, that is PW number 1, witness. Please make a glance, my lord. I humbly to read, my lord. So far, para 2 is concerned. That is the chief, my lord. 2 to 3 months before death of my daughter, one day my daughter was riding a Activa scooty and the accused was pillion reader. The accused created imbalance. While my daughter was riding the scooty, as a result, both of them fell down. Both my daughter and son-in-law, means present accused, my lord, that is Prasant Mahanti alias Sahib, my lord, sustained injury. The accused, by creating imbalance, while my daughter was riding the scooter, had attempted to kill my daughter. But this evidence was not a fire, my lord. So far the evidence is concerned, my lord, the evidence does not also lead any FIR, my lord. And this will be not only the version of the PW1, my lord, PW2, and the dated as well as PW10, my lord, happens to be Vijay Kumar Das, informant, my lord. The 3 witnesses inter alia categorically stated before the London trial judge that the incident was occurred by the husband and intentionally that incident was occurred to kill the Lakshmipriya, my lord. But so far the incident which was palpably wrong, my lord, and which is not sustained the eyes of law, my lord, because, my lord, no effort was lost by Vijay Kumar Das or wife Urmila Das or Dr. my lord. So my response submission, this is not also happened and there was no FIR. Then my response submission before the honorable court is, my lord, that is so far the PW number 1 is concerned, PW number 2 is concerned, 3 and 10. They have also stated regarding the distinction of the, my lord, that is the weapon. All are stated, the chopper was used. So far the PW number 23 is concerned, happens to be IO. He also stated inter alia that the weapon was used is not a knife but chopper. But so far as prosecution, so far as witness registered under section 161 before the police concern, my lord, all stated that the weapon was used like a knife, my lord. My response submission, that distinction was not also properly considered by the London trial court, my lord. And only the best submission before this honorable court is, it is a fact that the accused sustained injury, my lord. As like as deceased, my lord. The deceased also received amounting 17 number of witnesses, my lord. And the accused also sustained injury, my lord. And when the injury of the accused was not explained by the prosecution agency, my lord, that is a case, my lord, that is a great drawback. And my expulsion based on with the due diligence, my lord. So far, the injury of the accused is concerned, that was admitted by the PW number 2, PW number 1, and PW number 10, my lord. And when my expulsion mission, when the injury of the accused was not also explained by the prosecution agency, my lord, and when the case was not a cold blood murder case, my lord, and when there was a sudden quarrel and a sudden, because my lord, though there was a sudden quarrel existed between the two accused and the deceased, ultimately the accused sustained injury, my lord, in his palm, my lord, right palm and other bodies of law. That was not explained, my lord. And it indicates that it is a case purely or based on under section 304, part 2 of the IPC, my lord.
17 cut wounds on the body of the deceased. And you're saying 304, part 2. And sir, you're seriously arguing this? Are you really seriously arguing? With 17 cut wounds on the body. My lord, for part 2. My lord, witnesses are, this is a new thing that I've heard. I humbly submit. I have very little experience in criminal law, sir. I humbly submit. This is something new to me also. I humbly pray, my lord. I humbly give permission and report, my lord. I pray only one thing, my lord. Witnesses are ears as well as eyes of case, my lord. And the testimony, without testimony of the witnesses, my lord, a court becomes handicapped, my lord. And the witnesses, my lord, they stand as witness, they can explain the real truth, my lord. And the witnesses, they stand as witness, my lord. They have to explain the real fact, my lord. So all the witnesses, my lord, these are the father, these are the also wife, and the mother, as well as a sister of the deceased, my lord. When they categorically stated, there is a distinction of the weapons, my lord. And when they are categorically stated, because the law in trial court that accused sustained injury, and when prosecution did not discuss about the explain about the injury of the my lord, accused, my lord. That is really, my lord, I humbly submit below. And it is very topmost fact is that, my lord, the knife was also laying before the head of the deceased, my lord. If accused committed murder, he must have escaped himself by using by. Yes, sir.
My submission before the court is, if accused committed murder intentionally, he must have taken away the knife, my lord. Why the knife was laying near the dead body of the deceased, my lord? That is also sustained, my lord. That's casted a doubt about the prosecution case, my lord. And a prosecution immediately failed, my lord. Prosecution immediately failed, my lord, to explain real thing beyond the reasonable doubt, my lord. If accused has committed murder, he must have taken the knife, my lord, with him, my lord. And while the knife was laying, my lord, in front of the dead body, my lord. And when accused sustained injury, my lord, in his arm and palm and other's body, my lord, that was not completely explained by the prosecution agency, my lord. Not also taken into account by the prosecution witnesses, my lord. So that is also another case is another thing is, my lord, which is topmost, my lord, to present before the court is, my lord, one sided knife, my lord, who happens to be, who must have been intended, who must have been accused in this case, my lord. But he stands as witness, my lord. He was not treating as accused, my lord, because, my lord, prior to incident, my lord, there was a law of affairs existence of the deceased Lakshmipriya with the Sahidip Naik, my lord. Because the Sahidip Naik gave assurance to the Lakshmipriya that his son Divyanshu will also roll in his cinema, my lord. In this absent, my lord, both also connected to each other, and in many occasions, the accused physically saw the presence of the, my lord, Sahidip Naik, my lord, who also made a telephonic talk in a number of times, my lord, in a number of days, my lords. And said Sahidip Naik was also not earlier as accused, my lord. And even if he was also made witness, my lord, the prosecution agency did not examine that witnesses before the standing dog, my lord. That is also another dogma, my lord.
Sir, what is the statement of the accused under 313?
My lord,
Defense statement of vehicle.
So far, the defense statement before the trial court is that the charge, the home of the charge, which is drawn by the prosecution agency, is not correct, my lord. And the defense plea before the trial court is, my lord. I was also conducting advocate before the trial court, my lord. I have raised my lord objection in 4 to 5 counts, my lord. First count is the weapons. The case is purely based on 304B, 30 part 2, my lord, not 3021, my lord. Because, my lord, why, my lord? Because, my lord, I humbly submit, but there was no guilty intention, my lord. It is an admitted fact that, my lord, there was no guilty intention. Because on the night of the murder, my lord, on that night, the accused always deceased and their only son, they attended the dinner of the house, my lord. And being attending the dinner, my lord, they came back happily and peacefully enter into the house, my lord. So there was no guilty intention. On that night, the accused, the deceased was also committed murder, my lord. It was alleged that the deceased Lakshmi was murder on that night, my lord. That is 18 March 2015, my lord. Then my responsibility is due diligence, my lord. That is, my lord, no preparation to crime, my lord. It is admitted like that, my lord. There was no preparation to commit crime, my lord. And my responsibility, there was a sudden provocation, my lord. And my responsibility, the injury cause was not explained. The injury caused to the accused was not explained, my lord. These items, those have I leaded argument in argument and took evidence by making cross-examination, my lord, to the prosecution witnesses, my lord. That was not also explained, neither by prosecution agency nor my court, so far judgment of the trial court is concerned, my lord. Then my responsibility before the honorable court, my lord. Those are, my lord, my responsibility, one LD Naik, who happens to be a constable in Nimapura PS, my lord, and I mean RN Sethi, my lord. Those have registered the FIR, they were also not examined. They were also not found as a prosecution witness, so far charge sheet is concerned, my lord. And they are also not examined before the trial court, my lord. That is also another fatal to the prosecution, my lord. So far, role of the LD Naik as well as RN Sethi, those have registered FIR on telephonic talk by one person at the spot, my lord. They are also not examined. They have also either as a witness before so far the charge sheet is concerned, or so far a trial court is concerned, they are not examined and cross-examined. And even if the voluntary prosecution, my lord, though they have not also found a charge sheet witness, my lord, they can also call under section 311 of the CRPC, my lord, and they must have adduced their evidence to support the prosecution case, my lord. And it is pity to express that the law and trial court did not hold any point towards the role of the LD Naik and RN Sethi is concerned, my lord. Those are key factors to register a FIR, my lord. Then my responsibility. So far, PW 567, those are seizure witness, my lord. Those are seizure witness, including PW 6, my lord. They have explained the use of a weapon is a chapper, my lord, not a knife, my lord. However, all the other witnesses, my lord, they have explained the use weapon is a knife, my lord. And the use weapon is not chapper, my lord. But however, the seizure witnesses, they have also categorically stated, my lord, that the weapon was used is a chapper, my lord.
What was the blood on your shirt and pants, sir? What group blood was it?
But my responsibility, my lord. So far the use of weapon is concerned, that was knife was admittedly laid.
Sir, don't compel him to answer. If he does not want to answer, he will not answer.
Sorry, man.
He's such a seasoned lawyer. When he knows it's a difficult question, better not to answer.
I helped him, ask him to
I know. He's such a seasoned lawyer. He should know when the court is asking him a question, what he should answer, what he should not answer. Don't compel him to answer.
Sorry, man. I'm extremely sorry, man. Sir, my lord, so far the bronze train that is the pair of the dress of the accused, my lord. That was also sent to the chemical examination, my lord. And the board strain earth, my lord. That was also that was also sent to the chemical examination, my lord. But the chemical examination was also not available at the time of the examination. That was not produced before the trial court. And so far the weapon is concerned, my lord. That also not produced before the trial court at the time of the evidence. So far, PW number 4 and all seizure witness, internally as they categorically stated, they have not seen the weapon which was used in the alleged crime, my lord, at the time of the trial, my lord. And my response on mission. So far, PW number 4 is concerned, happens to be sworn, my lord. He also admitted in cross-examination that he has not seen the weapon today standing in the witness box, my lord. Then my response on mission. My lord, beside this, my lord,
PW 57. Shock. How is the same? It's not exhibited.
my lord, beside this, I humbly submit, I have also submitted a heap of decision, my lord, regarding the contradiction, regarding, my lord, use of the weapons, my lord. All those decisions were also not explained properly, not also taken into account by the law and trial court, my lord. And the law and trial court also failed to analyze, my lord, whether the crime, whether the alleged crime committed by the accused Prashant Mahanti alias Sahib, my lord, is a cool murder or it was a sudden provocation, my lord. Only the trial court hold that no, it is not a sudden provocation and it was a pre-planned murder, my lord. So in this juncture, my lord, I humbly submit, my lord, before this honorable court, I will be to file a sort of written note of argument along with a sort of decision, my lord, before this honorable court, my lord.
All right. Business. Whereas PW 26 is the doctor who conducted the postmortem report.
Yes.
It's page 140.
Yes.
Since the assertion is that it was a sudden provocation
yes.
incident, Millards may see page 140, second paragraph. There were 17 injuries, all are incised and cut wounds.
Yes.
Millards may go to page 141.
Yes.
Serial number 13. Multiple incised wound on both sides of neck. A on the left side. 4 injuries of size 2 inch into 1 inch by 1 inch. 1.5 inch into 1.5 inch into 1.5 inch. 1.5 inch, half inch and 1 inch. 3 inch, half inch into 2 inch. On the right side, 3 incised and cut injuries. Again, Millards, 2 inch into 1 inch into 1 inch. Number 14, cut injury of size 2 inch into half inch on the back side of neck. 16, trachea is bisected and all the large vessels on the neck are cut.
Yes.
Now, Millards, cause of death due to shock and hemorrhage as a result of injuries to the great vessels of neck that like jugular and carotid vessels on both sides. This is our postmortem report. Now on page 142, para 5, Millards, the doctor on cross-examination has clearly said that it is a case of homicide. All the injuries are antemortem in nature. So, Millards, it is clear from, and this, Millards, has not been challenged, Millards, that the injuries were antemortem. There were 17 injuries. And my lords, therefore, my lords, it is clearly homicidal in nature. Now, my lords, the prosecution's case rests on the depositions of PW1, 2, 10, and my lords PW4. The first point that my learned friend has raised with regard to the FIR not being read over. My lords, let me take you to my lords, the deposition of PW10, which is at page 105. Page 106, my lords, para 4, about 4 lines, my lords. I know reading and writing Odia.
Yes.
There is no endorsement on Exhibit 1 that the scribe read over and explained the matter to me. So, my lords, PW10, who's the father and the complaint, the informant, my lords, he knew how to read and write Odia. So, therefore, my lords, there's no occasion, my lords, for the scribe to, my lords, read over the FIR because it was not required. That is, my lords, the point with regard to the FIR not being read over. Now, my lords, PW1, 2, and 10, 3 of them say that the son of the deceased, who's PW4,
yes,
told them that his father has killed his mother because, my lords, it happened in the night, and in the house, my lords, there were 3 persons apart from the grandmother. And my lords, PW1 and 10 have, my lords, seen the deceased was lying on the veranda with her neck slit and bleeding injuries on, my lords, 9th of March 2015 in the morning when they came to know that such an incident has happened. My lords, let me take you to, my lords, the deposition of PW1 first, which is at page 84. Para 3 minutes.
Yes.
On 8th of March 2015 night, both the accused and my daughter and grandson Dibyanshu had come to our house and have taken dinner and returned to their house. The house of the accused is in our village across the road from our house. One Bullu Mahanti, a neighbor, called us in the morning and told that my daughter was lying with bleeding injuries. We went to the house of the accused and found my daughter Lakshmi Priya had been killed and she was lying dead with bleeding injuries. The throat of the deceased was slit. Then the next line, Millers. At the time of the incident, grandson Dibyanshu was 7 years old. Dibyanshu told that in the night his father killed his mother with a knife and he cried. And this, my lords, has not, my lord, there is no inconsistency that has come out in the examination. Now, my lords, let me take you to, my lords, the deposition of PW10 with regard to this, with regard to this particular point. As the deposition is at page 105.
Yes.
About the 4th line, my lords. It starts with, on 8th of March 2015, my daughter had come to my house with her son. The accused also came to my house. They took dinner in my house and went to their house. The accused went to his house with his son first. After 5 to 10 minutes, Lakshmi Priya went to the house of the accused. On the next morning, so-and-so and his brother Bullu called me and told me to go to the house of my daughter. I went to the house of my daughter. I found my daughter lying dead in the bedroom. My daughter had stabbing wounds on belly, slit wounds on neck. The accused was not present in the house. Mother of the accused and my grandson were present. Grandson Dibyanshu, who was aged about 6 years, told that his mother was killed by his father with a knife. PW2 who is Millard's the sister, she also corroborates the same thing, which Millards will find at page 89, Millards. Para 4.
Yes.
That's about 7-8 lines down. Dibyanshu was brought to our house. He was shivering. He told that his mother was killed by his father. He also told that his father sat on the chest of his mother and slit the throat of his mother. Let me, Millards, now take you, Millards, to the evidence of PW4, who's the son and who is the sole eyewitness, Millards, to the incident.
Yes.
Well, the deposition starts at page 95, Millards. He first answers the question, and Millards will find a remark, Millards, which is after the fourth question. Are you reading? Yes, standard 1 in Venkateshwar English Medium School, Nimapada. The child witness is able to answer rationally and he is competent to give evidence in court. Millards, this is the finding of, Millards, this is the opinion of the trial judge, and Millards, I'll show judgments which say that the opinion of the trial judge with regard to the relevance of the deposition of a child witness and what is to be attached to it. Millards, third line, Millards. After taking dinner, father and myself returned home first and then mother came. Mother was washing utensils. Father dragged mother and dealt blows with a big knife to her hand. Grandmother took me and kept me in the room. So, Millards, the child has seen that his father dragged his mother and started hitting her with this knife to her hand, Millards.
Just see the cross-examination. Come
Yes,
to para 2.
Yes, Millards. Millards, para 2, Millards. Where, Millards, this son.
No, just read,
Yes,
please.
I love mother more than father. EVS, English, Odia, maths are taught in our school. In Odia subject, a story was told and cannot say the name of the story. Before the incident, father, mother, myself were staying in a rented house at Puri. It is not a fact that one Sandeep's uncle wanted me to act in a film, and I had seen Sandeep uncle 2 to 3 occasions at Digalo. After returning from maternal grandfather's house, there was no quarrel between father and mother. I had seen quarrels between father and mother before the incident. The quarrel between father and mother was for money. Before the incident, I had visited maternal grandfather's house for house 1 or 2 occasions. I cannot say size of the big knife. I narrated the incident to maternal grandfather in his house. It is not a fact that there was no crowd on the road in front of our house. I do not notice the alleged knife.
So basically, nothing has been elicited.
Please.
Nothing has been elicited to contradict
Millards,
yeah.
PW4's and Millards, this has been corroborated by Millards PW1 and PW10.
Right.
Millards, so therefore, Millards, it is clear that it's a homicidal death, Millards, as per PW26's deposition and PM report. Millards, PW1, 10 and PW4's evidence goes unchallenged. There is, Millards, another issue with regard to the nomenclature of the weapon, Millards. The weapon, Millards, is not disputed here.
It's a sharp-edged weapon.
That's right, Millards. And Millards will see the FSL report, which is at page 145.
But that, he says, was not exhibited.
Millards, Millards, that the IO says that he hadn't got the FSL report till filing of the charge sheet.
So what wasn't exhibited? It wasn't proved.
Millards, that Millards says does not come. So therefore, Millards, the trial court
No, he's made a point about the injuries on the accused. He says that has not been explained.
Please, Millards.
Injuries on the accused has not been explained.
Pardon, Millards, I couldn't hear.
There was an injury with the accused, which has not been explained by
Millards, PW 24 Millards has examined that. My lords will find it at page 130. On 11/3/2015, I was working as medical officer CHC Nimapada. On the day at 10:45 a.m. on police requisition, I had examined Prashant Kumar Mohanty, son of so-and-so, and found superficial cut marks anteriorly on both palms. This is my report marked exhibit so-and-so and my signature.
So these were superficial cuts.
These are superficial cuts. So he says that I have not mentioned the number of superficial cut marks.
Come to para 7G, page 46 of the trial court judgment, internal page 24.
Please, minutes. Para 7 minutes.
Small g.
My lords, fourth line, my lords, is page 47. In the present case.
No. Please. Para 7G, bottom.
Yes, my lords. The learned counsel for defense urged that the prosecution has not explained the injury sustained by the accused, and so the case of the prosecution is doubtful. Exhibit 14 is the injury report of the accused, and PW 24 is the doctor who had examined the accused. According to PW 24, he found superficial cut marks on both palms of the accused. In the present case, there is direct evidence that the accused had committed the murder of the deceased by means of a knife having length 29.5 cm. While the accused used such a knife to deal multiple blows, it is natural some sort of superficial injury might come on his palms. Thus, in this circumstance, non-explanation by the prosecution is not fatal to the case. In this regard, the decision of the apex court reported in so-and-so, wherein it was held, the court has held that there might be cases where the non-explanation of the injuries by the prosecution might not affect the prosecution.
All right. Yes, sir. What do you want to say?
Only I can take your attention with the complaint. Please make a glance. That is the witness of the deposition witness 25. Prabhas Chandra Sahu happens to be IIC of the Nimapada PS. Please make a glance to page my letter. That is page 135. Please make a glance. Last line, para 9. It is a fact that there was no endorsement of scribe on the exhibit 1, that is FIR, that the contents was read over and explained to informant. It is a fact that in the same said incident, the accused sustained injury in his palm. So my responsibility, my counterpart lawyer vehemently argued before this annual court, inter alia contended that the endorsement of the FIR was read over to the informant by law. But the material witness, likely Prabhas Chandra Sahu, happens to be stand as witness number 25, standing in the witness box in his cross-examination. So para 9 is concerned, he admitted that it is a fact that there is no endorsement of the scribe of the exhibit 1, that is FIR. Then my responsibility. Please make a glance to the para 10, running page 136, my lord. 136. I am the humbly permitted to read, my lord. Para 10. I was the IIC Nimapada police station while investigating the case. I got information about the case from Sub-Inspector I.N. Sethi. To my knowledge, I have received the information over phone. I cannot say the person who had informed over me the phone. It is a fact that I have not examined SI R.N. Sethi during my investigation. That is also own admission, my lord.
All right.
Then my responsibility. I have not, para 11, my lord. Please make a glance. Page 136. I have not implicated a Saib Sahu, either an arbitrate abater or accused, which vehemently argued before some for that, though Saidip Nayak has a role and law happens with this is Lakshmi Priya, he must have been added as accused, but in cross-examination, para 11, the INC Nimapada happens to be Prabhas Chandra Sahu admitted that I have not implicated Saidip Sahu either as an arbiter or accused in committing crime. My investigation reveals there was a telephonic conversation between the deceased Lakshmipriya and Saidip Sahu. It is also on admission. There was a telephonic talk which was existed between two. Then Lakshmipriya with the Saidip Sahu. LD Sahu constable bearing number 622 is not only witness to the seizure but also witness to the scene of the crime. I have not examined the team of members who had accompanied with the Partha Sadi Sahu, scientific officer, DFSL, Puri in inspection of the spot. Then my response submission, that is before the court is my lord. Please make a glance to the page 137. Please make a glance of the said witness, my lord, para 15. I may be calling to read, my lord. It is a fact that the opinion of the examiner of the SFNCL was not received by me till submission of the charge sheet. Till submission of the charge sheet, it was not submitted, my lord. The forensic laboratory report is a vital, my lord. It is a key factor, my lord, to ascertain the injury, to ascertain the cause of the death, my lord. And when it was not submitted to the charge sheet, my lord, so far charge sheet is concerned, my lord, there was a defect in the investigation, my lord. The investigation conducted by the concerned IO, my lord, is a defective one. And so far as charge sheet is concerned, my lord, that was submitted before the trial court is also defective one. Then my next submission, I have obtained the similar from court of the production of the material objects. So these are my submission, my lord. I humbly permit my lord before some court. I may be permitted to file a short written argument and citation.
Orders reserved. Both parties are permitted to file their written notes of arguments within 1 week.
Grateful. Supplementary list item number 55.
My lord, this matter, respondent number 3 has died, and I have filed a substitution petition IA 2744 of 2022. Honorable Court may kindly consider to allow the substitution petition and direct issuance of notice to the proposed LRs, my lord. I have mentioned in the schedule, my lord.
The IA is not listed. What's the IA number?
It has not come, but I have filed number is 2744 of 2022. I am having the copy, my lord.
I am the respondent, my lord.
I have given a copy to him.
Today I have received the copy, but the Sobhendra Narayan Bhandadev is the opposite by the respondent to my lord. He has died on 5/9/2021, my lord. And he has every knowledge, the petitioner applicant has every knowledge about the same.
You not ask for continuation of delay, sir.
My lord, see, my lord, it comes out of rate application. In rate application, order 22 rule 4 is not applicable.
Doesn't mean that you can file it whenever you like, sir.
And the residual clause of the limitation act is 3 years. That I am also say I will just file it. If you say I file it. I will later knowledge, my lord, I thought it was necessary.
Sir,
you have filed 2 petitions, 2 more petitions. I will file it.
The OLR case of 76 in year 76, my lord.
That already I am satisfied.
This is single bench order, my lord. The Tahsil was final order was passed, my lord, which was challenging the appeal, my lord. Also disposed of. But the rest
final challenge the appeal, my lord, the order of the Tahsil has been set aside, and they have another set aside, my lord. They have another application here that we are saying.
In the petition, the filed this substitution petition in 6 months before, my lord. But he has been knowledge. But in today, has filed this is the mistake.
The court is informed that of respondent number 3.
Respondent number 3. 3 has expired. 3 has expired.
On
5/9/2021.
5/9/2021. Counsel for the appellant undertakes to file an application for. States that he's already filed IA number.
IA number 2744 of 2022.
2744 of 2029. For substitution of respondent number 3 by his LRs. So, however, the said IA is not on record. Paragraph. Counsel appearing for respondent numbers
1, my lord.
Respondent points out that the above IA is not accompanied by an application for continuation of delay and for setting aside appointment. Counsel for the appellant states that he will file an application, appropriate application for that purpose as well. List on 1st November.
Supplementary list item 56.
Item 56, my lord, a PIL on the same issue is listed on 11/10/22, 16602 of 2016. Okay, list along with 16602 of 2016 on 11th of October 22. 11th October 22. All right.
Supplementary list item 57.
Please, your lordship. Per your lordship's last direction, the state has filed an affidavit. Now, only 11 blood banks are there where this NAT system they have installed. They are all total 55 blood banks. And so, where this system is not installed, when a donor donates a blood, it takes 30 days time for HIV to be detected under the current system of ELISA test. But in this system, it can be detected within 7 days. And I have also filed the RTI report that since introduction of this test, 434 units of blood, which were otherwise available for donors, that were detected HIV positive. So they have to install this NAT mechanism in all blood banks. And they have filed a supplementary
affidavit I have filed on 8th August.
That they are examining the cost-benefit analysis. My lord, in this serious issue, cost-benefit analysis has no scope at paragraph 4.
Yes.
So let them give a timeline when all the blood banks will be.
In the supplementary affidavit filed on behalf of the opposite parties, it is stated inter alia that of the 11 blood centers in the state, you say, the 11 blood centers in the state have adopted the NAT PCR testing technology. And at present, 47% of the total blood collections of the state are being tested through the NAT method. So it is further stated that the government would take, open quotation, a suitable decision for expansion of NAT facilities at other blood banks in the state, on the basis of the observations of the 5-member committee constituted for the purpose, unquote. It is seen from the said affidavit that the above 5-member committee is supposed to examine the open quotation efficacy of the scheme with cost-benefit analysis, unquote. The court would like to impress upon the government that the NAT PCR testing of all the blood samples collected, of all the blood collected, has to be made mandatory in order to ensure that the blood that is made available is free from all possible contaminations. We'll stop. Consequently, the direction is issued to the committee to conclude its deliberations within a period of 4 weeks from today and submit a report to the government.
2 months.
All right, 8 weeks from today and submit its report to the government without being limited by any single court's cost-benefit analysis, unquote. Since it is mandatory that only uninfected blood is supplied to those in need of it. A further affidavit be filed with the state government, enclosing a copy of the committee's report before the next date. List on 9th November.
Supplementary list item number 58.
Same, this is the same Amulya Ratna Panda.
Yes, my lord. I think yes.
He's still not appearing. Pass over.
Supplementary list item number 59.
May I please, Lordship? This matter relates to installation of PET CT scan. Last occasion, Lordship directed the State Council to file an affidavit to compliance of the order dated 12/4/2022, as well as the Acharya Area Institute assured this court that will be started by 29 June 2022. And Lordship kindly see
where is Mr. Panda?
Mr. Panda, my lord, so far as our instructions are, my lords, we are waiting for the AERB approvals, my lords.
You're waiting for what approvals?
It's the Atomic Energy Regulatory Board approval for the license and to start, because everything has been installed as per the.
Mr. Party?
Yes, my lord.
Why is that getting delayed?
My lord, I don't have a knowledge. If Mr. Ponda will give some documents, then immediately I could take up the matter.
You see, Mr. Panda appearing for the Acharya Harihar Institute states that they're not able to commission the PET scan facility because of lack of clearance from the Atomic Energy Regulatory Board, bracket AERB. Mr. P.K. Padi states that he'll seek instructions. A complete set of papers be made available to him forthwith. What was the other issue, Mr.
I was supposed to file an affidavit. Lordship may grant me some time because
B.K. Mohanty, learned counsel appearing, AGA, appearing for the government, speaks and is granted 4 more weeks to file an affidavit as regards making the said facility available at other centers. List on October 19th October.
Yes, ma'am.
Right.
I may be permitted to draw your lordship attention
to your application. You have to respond to that application as well, Mr. Mohanty.
Yes, ma'am.
My 3 sunsets.
Yes.
Case number 11176.
Correct.
Yes, that is a miscase.
Both to the, you say, seeks time to respond both to the, and also to file a reply to the application of my 3 sunset. All right.
Copy make I leave, sir, madam.
All right.
Small
request to all of my friends to provide the documents within 3 days. I will took up the matter immediately.
Right, sir. Right.
I have got a small submission to made, my lord. Small submission to made. One cancer patient, my lord, day by day it is deteriorating. Your lordship knows, everybody knows. The one cancer patient from Kandhamar who is now waiting for an operation in Acharya Harihar for last 20 days, my lord. He is not been operated. He is in the voting list. I would like to place the copy of press clipping of the new item.
Sir, either file an affidavit, because how do we put it to the other side? The Acharya Harihar lawyer has to take instructions.
My lord, I will file a miscase, my lord.
Do that.
My lord, oblige me.
All right.
Supplementary list item number 60. Item 60.
May I please?
But in fact, there is
here again, there's a delay application.
There is no delay, my lord. This order was passed on 20th July 2021 and filed on 8th March 2020.
All right. For the reason stated, the delay is condoned. Yes. What's the matter? What?
That's, madam, I have prepared a short date chart. It is with.
The notice is not gone in this, sir.
This is regarding that work charge employees, the direction has been given to release their pension in their favor. May I drop my lord's notice the order of the Honorable Court at page 23.
What has happened to the Narasu Pradhan's case?
Narasu Pradhan, my.
The SLP is also dismissed.
Yes, my lord. In similar matter, one matter was remanded. I have given that in my date chart. You also can find it from that. I have annexed judgment of this Honorable Supreme Court. In my date chart, page 29. Because what has happened in previous matters, all the rules and circulars have not been taken into account. Let's see page 29.
All right, we just say notice returnable. 21st November. Notice additionally be served on counsel appearing for the respondent before the learned civil judge. Is there a contempt petition?
Yes, but that contempt application has been filed. That has been disposed of. Contempt is disposed to implement that order.
All right. Meanwhile, the impugned order shall remain stayed till the next date.
Item 61.
May I please? My lord, kindly have a glance to your lordship's order dated 11/4/2022. Last chance given, they have not complied with. 11/4/2022. They have failed to produce the sanction letter for installation of statue.
My lord, I have got the instruction, my lord. So for the specific letter for installation of the statue is concerned, since that is given to the school management committee, and school managing committee have decided in by virtue of a resolution in which we have filed in the counter, to which the petitioner was also one of the signatory, and he consented for the installation of the statue. And now coming forward that particular one statue, why it is being installed. There was a decision to install 7 statues within the school premises. I have given the description in the counter affidavit. And
a simple point, sir. Did government give the approval or not? That's the only question, not whether the committee decided or not.
No, did
the government give an approval? Did the sanction was it granted by the government?
No, my lord, that was no specific.
Then how is it legal? The whole question is, without such sanction, can statues be installed in a government school? It's an aided school or a government school?
No, that is
a government school.
Taken number school, and the school managing committee has been constructed by virtue of the section 21 of the Right to Education Act, my lord. And that school management committee was entrusted upon the responsibility out of which the beautification and
school management committee can decide on its own. Does not have to seek permission of the government.
No, that since the government has given that
the government is delegated to the committee that to decide whether to have a statue or not. What are you saying, sir?
No, my lord,
there is a committee which will decide whether they want a statue or not, but this committee don't have to seek permission of the government.
No, I have the guideline of the government. I will file it in the shape of affidavit.
No, you tell us simply this.
No, that
is sanction necessary?
No, my lord.
Question number 1. If sanction is necessary, was sanction granted? Question number 2. No, without sanction being granted, how a statue is installed? Question number 3.
So sanction. So far the sanction part is concerned, that is no sanction is necessary, as has been informed by the officer, and the document has been supplied to me, which I will have to file in shape of affidavit indicating
that last opportunity is granted to you more than 2 months ago. 2 months ago.
11/4, my lord. I do concede, my lord.
Yes.
Day before yesterday,
then let you pay the costs, sir.
My lord, may got 2-3 days time at least, because I have received the guidelines.
So there has to be some meaning for the words last opportunity, correct? We have used those words last opportunity in the last order. There has to be some meaning for those words.
I'm sorry, I have not taken note of that last opportunity.
But the problem is it is staring at us now. We have all these orders with us.
Only your
You have the luxury of not applying, not taking copies of orders, but we don't have that.
My lord.
It is staring at us, our own words.
I'm sorry, my lord. But
I'm also very sorry, sir. So I'm saying you pay 5,000 rupees as costs.
Only 3 days time.
You take 3 days, you pay 5,000 rupees as costs.
So that
despite the last opportunity having been granted,
my lord, the
state has not filed the affidavit as directed more than 4 months ago on 11th April 2022. Accordingly, subject to payment of, you see Mr. Mahapatra, London Council appearing for the opposite parties, states that he will definitely file the affidavit in 3 days' time, that is on or before 26th August 2022. If the said affidavit is not filed on or before 26th August 2022, costs of rupees 5,000 will be paid by the state government to the High Court Bar Association Welfare Fund, and proof of payment of costs will be placed on record before the next date. List on 7 September.
Published. Supplementary list item number 62.
This is that matter regarding reappointment of IAS officer for a period of 1 year after retirement.
So far as I am concerned, I'm appearing for the bank. I'm filing the counter just now. I've already given a copy to my learned friend.
All right. Lordship may kindly see order dated 4th of July 2022. It's a total period of 1 year appointment, which I'm challenging, my lord, in this writ of querent. Now, your lordship specifically granted them liberty to file counter within 2 weeks' time from 4th of July.
Correct.
And today they are filing the counter with a copy to me in the court, man.
So far as the bank is concerned.
We both the state and bank, both of them are filing counter today. Despite your lordship directed on 4th of July 2022, giving them 2 weeks' time. Feeling the urgency that it is for 1 year. If it is not,
Hey.
So your his argument is that since the process of selection is yet to be completed, IAS officers of the state found suitable to the post are being deployed intermittently to work as MD. Is this your defense, sir?
So the state is concerned state.
We have filed our counter.
I am appearing for the concerned person. We also have a issue regarding maintainability because the petitioner actually belongs to a political party that has not been disclosed. All those points we have taken. So
but
this
I am not supposed to disclose when I passed HSC.
There's a specific rule that he has to disclose that he belongs to a political party. There's a personal malice which is involved. All those issues will come up.
Kindly see para 11 of the state's counter, my lord. It will go upper to the face of it. How have they abused their own position? Kindly see para 11 of the state's counter, man. Kindly see. How have they abused their own position and their own circular, man? Kindly see. Para 11 of state's counter. Their own circular says that in case of appointment of a retired employee, they will follow a process of selection, advertisement, entire thing. Their own circular says that. In para 11 say that in view of the appointment for 1 year, dispense with the selection process. Kindly similar. How can they dispense with the selection process in a public employment? Para 11 of state's counter.
Yes. It's a long paragraph.
Yes, let me paste it. The contents of the petitioner that re-engagement OP number 7 has been made in clear departure to the GA department comprehensive guideline resolution number so and so dated 27 August 2014 is not correct and is denied. In this regard, Corporation Department has come out with an advertisement calling for application for the post of managing director OP number 8. The advertisement was brought out in 2018, pursuant to which a search committee was constituted. Means a regular appointment in 2018, not concerning this. Now you actually see.
No, you next line.
Yes. The advertisement was brought out in
2006 bottom. It will be pertinent to mention.
Yes. Government servant by resolution number so and so of the General Admission Department envisages re-employment initially for 2 years, which can be extended for subsequent period of 2 years with a spell of 1 year each. In this case, the re-engagement of OP number 7 is for a period of 1 year, which can be terminated at any time. The requirement of para 4 of the said resolution stipulating selection process of open advertisement has been dispensed with, considering the period of engagement to be done 1 year, and that till process of selection for a full-time managing director is completed. But kindly see 2014 whether there is a power of dispensing with this advertisement process. It's not there.
Let the state's counter be given on us. I am appearing for the concerned party. Let that affidavit be given to us. We will it's a short date. So we will not shy away from hearing.
Or at least say the affidavits of.
We also have a point
1 to 4. That is the state, and opposite party number 8 That is the Orissa State Cooperative Bank have been handed over in court. Copies thereof is served on counsel for opposite party number 7, whose appointment is being challenged. To enable him to file a response to both the petition as well as the above affidavits before the next date. The petitioner is also permitted to file a rejoinder to the above affidavits before the next date.
Lordship is taking up next week now?
Take it up on 14 September.
Okay.
All right.
Supplementary list item number 63.
May I take the liberty from your Lordship, Lord? That item 65, which I mentioned on the first hour before your Lordship, Lord. In fact, probably I could not communicate to your Lordship. That's a matter, my Lord, which was being heard by my Lord, Honorable Justice Jaswant Singh and Mr. Ramana.
Oh, yeah, we sent it to that bench.
I am also requesting the Honorable Court to get a return back so that your Lordship can pass appropriate order.
No, we've corrected it. We've already corrected it. The record is also there now.
That's right. It has gone there.
Yes.
Well, as item 63, my lords had directed me to file a rough map. My lords, I filed it yesterday.
We have received the affidavit yesterday evening only, my lord. We have to check it up and obtain instruction.
Let them, my lords, file a report. My lords may see the affidavit, my lords, the map at least. The affidavit just says the map. Yes.
This 63 is it? There are 2 copies here anyway. Anyway.
This page 7 is where the map.
Correct.
No plot numbers have been mentioned.
My lords may see, my lords, there's a legend. My lords may see P1, my lords.
P1 only plot where the school is there. Yes, that is the record of right annexure 1 says, but here they don't mention where the school plot number. Where the school is there, no plot number is mentioned.
My lords, it's a,
so we seriously dispute. We want to obtain instruction on this, my lord.
All right. You see, the affidavit of the state government has been handed over. Opposite party number 4, bracket state, has been handed over in court. Mr. Jena, learned counsel, the petitioner seeks time to respond to the said affidavit. List on
interim order to continue.
Yeah. 21st September interim order to continue.
Supplementary list item 64.
May I plead your lordship? My lord, as per the direction, my lord, I filed the postal receipt today.
All right. You see the petitioner's representation dated 17th May 2022 shall be examined by opposite party number 3.
Yes, my lord.
And after issuing notice to the petitioners as well as opposite parties 4 and 5. And after giving them a hearing, a reasoned order shall be passed thereon.
My lord, I have a small prayer, my lord. Till the disposal, the bill should not be passed.
Oh, no.
They are preparing the bill.
It's all right. So whatever they do, you can ask the collector to hold this act.
My lord, the collector is not cooperating.
Also,
2 weeks, 2 weeks before, my lord, we have informed him that we have filed an PIL, but he is not taking care.
Not later than 14 November 2022. No precipitate action will be taken by the collector before the above date. Copy of the copy of the order be made available to the parties not later than 21st November 2022. Prior to the said date, no precipitate action will be taken by the collector. The petition is disposed of the above.
There is a Passover item.
Yes.
I may be permitted 15 days time. I will give update report.
That Jagannath temple matter.
Jagannath temple.
You want some time to give a report.
So you please visit the place. My request to you is without visiting, without taking proper. You have to physically visit, sir. Only then you'll get a proper idea of what is happening, what is not happening.
I may be permitted.
All right. You see, Mr. Manthi Leonard Amicus Curiae states that he will himself visit both the Konarak, the Puri and the Konarak monument, Puri temple and the Konark monument.
Puri only.
Both.
And file an affidavit indicating what specific directions are required from the court by him. The affidavit be filed
I'm not supposed to.
at least 1 week prior to the next date with an advance copy to counsel of the state to enable him to take instructions thereon. List on 18th October. Sir. All right.
34.
Pastor matter supplementary list, item number 3.
Item number 3. Item number 3, my lord, the appeal is being filed by the state. May I pray your lordship may fix another date for hearing with a permission me to take the Xerox copy of the brief because there is a misplacement of certain documents.
Counsel for the state is permitted to collect a soft copy of the paperwork by producing a pen drive before the next date. List on 26 September.
Pastor matter, item number 8.
This is a writ appeal. I have submitted a date chart, my lord, final hearing. The issue involved in this case is an employee of a government corporation was transferred and because he did not leave the quarters, the old place of posting, penal damage was, penal interest, penal rent was levied. He came to this honorable court. This honorable court passed an interim order that you give an undertaking that if you fail, you will to pay at the penal rent. He also gave an undertaking. That is annexed in the writ petition, my lord. Then I filed date chart. Then ultimately that writ was dismissed. Not no order passed for. Direction approached the authority. Authority rejected the representation. Then that was not that rested there. As a retirement, his dues of penal damage, penal rent amount of 2 lakhs odd record from the leave salary, others. The rest amount was record from the gratuity. After receiving that, he challenged before the payment of gratuity authority, who without considering our objection, said, no, you cannot deduct from as per section 13 of the PG Act. You cannot deduct. I filed appeal. We have pointed out in the statement that he has given undertaking by this honorable order. On the basis of that undertaking, we have deducted from the gratuity. And then the Supreme distance also, I don't know why.
This is only for 57,000. You are
15,000.
What is 57,000, sir? The man,
he is a complete. He transferred, did not leave the court informatives. It's
there are people not retired, not vacated for years, and he at least vacated in 4 months. 4 months after retirement, he vacated. 2 lakhs and all. No, the whole present dispute is only about 57,000. That amount is recovered from the gratuity. That's correct. It's only 57,000. So let's not keep. You say the actual amount involved is rupees 57,090, which was recovered from the respondent's gratuity. Pursuant to an undertaking given to him about paying penal rent for overstaying in the official quarters. Paragraph. Considering that the amount involved is not substantial, leaving the question of law open, the writ appeal is disposed of.
I have cited my lord distance. This honorable court, Supreme Decision have cited.
All right.
Pastor matter, item number 34. Item 34.
34, may please. In this case, this honorable court issued notice in 2009, my lord. But till now, they have not filed a reply, my lord. Notice was issued to all the opposite parties, my lord.
My lord, in fact, in this case, the oppositive parties made, but the oppositive number 1 is nowhere concerned, my lord, because
no. So your concern is only about appointing full-time chief executive officer of the Waqf board,
my lord,
and Hajj committee.
My lord.
So what is your instruction on this, sir? Why is a full-time chief executive officer not appointed?
I think yesterday one Tushar Kumar Mohanty, he joined. Yes, yesterday the notification
has been
I just received it from Facebook that there is a government.
No instruction, my lord. Your lordship may kindly record the statement.
No. I must
We
get
will
the.
place that, my lord, let it come next week.
All right, at the request of Council for the State as well as Council for the Waqf Board.
Waqf Board.
List on 15 September.
Published.
All right.
Pastor matter item number 52.
44.
44 is already called out. Anyway, tell us what it is about.
It is
44.
Tell us what it is about. It is already called out. This is the second round, madam.
44. May I place the?
Yes.
This is with regard to the villagers of Lachipur, my lord. They have filed this public interest litigation for
Matrumangala Kendra. Not to demolish Matrumangala Kendra.
Matrumangal Kendra and RI office, my lord. May I take your lordship to page 61? Government has admitted that yes, that over that property, Matrumangal Kendra and RI office is continuing, functioning. But still then that has been sold out by some person to another person, my lord, and they are those opposite parties are very much influential people, and he is acting as the sarpanch. So they have grabbed that property, and no action has been taken by the collector nor and the petitioners villagers. They have made representations to the Tahsildar collector, but no action as yet. 61, your lordship.
Correct. Yes, sir. Mr. Monty. This counter affidavit you are admitting, who's appearing in this matter?
Item 44. Yes, my lord.
424427 of 2019.
Yes, my lord. Just. Yes. Oh, it was dismissed for default. There is no counter affidavit. Yes, there is a counter. Yes, my lord. Sorry, I'm sorry. There is a counter affidavit.
Page 61, that internal page 6.
Yes.
After knowing
the fact from report of the RI Lachipur so the then opposite party went to village Lachipur and tried to solve the dispute for the better interest of the public, but to no avail. Steps are being taken to find out as to whether plot number so is a government plot or private plot. Once it is found that plot number so is a government plot, immediate steps will be declared to declare the sale deed as void. The document available as on date shows that Rukmini Patnaik and are the recorded tenants of plot number.
So you'll have to file a further affidavit.
My lord, one thing if his sale deed, he is claiming that my learned friend is coming, that sale deed is a void document. How the Reed Court will take a decision on this? Let him approach the appropriate civil court to declare it is a registered
document. Yourself should take. No? See, the government itself, once government finds out that this is a government plot, no sale deed can be registered in that regard.
No, that
you yourself have said once it is found that it is a government plot, immediate steps will be taken. You have said that.
Because as far as my knowledge, to declare a registered sale deed void or ab initio void, only the civil court is competent.
No. That is between two private parties. If this is the government itself,
it can be avoided.
The government itself, if the government finds out that its own plot has been registered,
then I have to get the up-to-date instruction. What is the?
You say in the affidavit filed by the Tahsildar, it is stated that if it is found that plot number 367 is a government plot, then open quotation, immediate steps will be taken to declare the sale deed as void, unquote. Mr. D.K. Mantil, learned AGA, states that he will file a supplementary affidavit before the next date with an advance copy to counsel for the petitioners to indicate what steps have been taken by the government to inquire into the matter. List on and take corrective actions. Inquire the matter and take corrective action. List on 17th November. After lunch.
supplementary list pastor matter item number 52.
52, my lord, kindly take this matter after 1 week. Within 3 days, we will file the deposition copy, my lord.
You will file what?
A deposition copy of the statement of the witnesses, my lord.
So paper book is there.
Paperwork is already prepared.
The entire paper book is there.
Paper book has already been, my lord. So only may kindly.
He is Mr. Panda. So you are Mr. Panda.
No, he's
No,
not
my
Mr.
lord.
Panda.
I am from the junior to Mr. Satyajit Raut.
Satyajit?
Satyajit Raut. My name is not reflected in the call list. I am newly joined, my lord. So kindly, my lord.
Your wakalatnama is there.
No, my lord. On behalf of my lord.
No. Whoever you are on behalf of who?
Amulya Ratna Panda.
Okay.
My lord. Item 52 and 58, my lord. Same cases, kindly.
52 and 53?
58.
58.
My lord.
Okay, you say the request of Mr. Amulya Ratna Panda, Leonard Counsel appearing the appellant. Based on 19th October.
My lord. Obliged, my lord. Itself.
19th of October.
Weekly list. Weekly list for hearing. Item number 1.
Yesterday, Mr.
But
Katkia was
item Mr. Katkia will be conducting. He's today he's gone to out of station, my lord.
All right. Stay on board.
Weekly list item number 2.
May it please the Lord. Before going to the facts of the case, my lord, I just want to draw my lord's kind attention to the settled position of law, foul of the crime, higher the proof. Here is a case, my lord, where the appellant has been convicted for the offense under section 302 of the Indian Penal Code, though he was placed on a trial in the court of Pradhan Sessions as Balangir, along with 2 others under section 302 by 34. But the 2 others, namely my lord, Chittaranjan Mahanti and Naresh Kumar Nag, they have been acquitted before on the date of accused statement under section 232 of the Criminal Procedure Code, my lord.
Yes.
My lord, the case as depicted by the prosecution through my lord PW8. PW8 is the investigating officer who was the then sub-inspector of police. He got anonymous call that Gondagod is going on in Palace Line, Balangir at around 12:45 p.m. On receipt of this anonymous call, he went to the spot and found that one Anantanath, deceased, was lying with pool of blood. Say blood was around, and that too the crushing, that is the crushing in front of Sonal Electronics. He, after perusal of the injuries concerned, he could understand that it's a case of murder. He registered, he draw plain paper FIR there, registered a case under as because that reveals a case of 302. He draws the FIR and forwarded the same to the inspector in charge, Palace Police Station, my lord. That FIR is Exhibit 5. And on being directed by the inspector in charge, he investigated into the case to a particular date and handed over the same to PW9, who submitted charge sheet. Well, if the case of prosecution will be considered, my lord, to substantiate the allegation, prosecution has examined around 10 witnesses, out of which, my lord, PW1 to 4 have turned hostile. 5 and 6 are witnesses to seizure of some wearing apparels of the deceased under Exhibit 3 and 4. PW8 is the informant cum investigating officer of the case. He handed over the investigation to PW9, who ultimately submitted charge sheet, and PW10 is the doctor who has conducted postmortem examination under Exhibit 9. And prosecution has relied upon the evidence of PW7. PW7, the wife of the deceased, who can be termed to be a chance witness, because case of PW7 is my husband, who is the elder brother of the appellant, present appellant. He was staying with me in my father's place since before 9 months before the occurrence. On 12th, date of occurrence is my lord 17/4/96. My lord, may kindly take note of 17/4/96 is the date of occurrence.
Yes.
On 12th/4, he stated that I'm going to my father's place because they have my brother has purchased a vehicle. So I have to take the vehicle to a different place. He says Tata 407.
Yes.
I will drive the vehicle and to go to a particular place. So saying, he left his in-law's place and came to Balangir. There, my lord, when he did not turn up as promised by him, it is stated by PW7 that I came to Balangir in search of my husband, and while I was approaching on the road near Palace Line, I saw the appellant is assaulting my husband. I saw the same from a distance and returned back to my village. My lord, may kindly see this. This is very, very important in the sense that PW7 says, I saw the assault on my husband from a distance place, and after seeing the same, I returned back to my village, informed the fact to my father. After informing the fact to my father, I again came back to Balangir and ascertained about the dead body of my husband. On hearing that the dead body has been shifted to hospital, I went to the hospital where postmortem was going on. Again, I returned back to my village. I stayed there in my village. And on next day, on 18/4/96, the investigating officer reached in my village and I was examined. Question has been put by the defense whether, because she says she got down in the bus stand at around say 11.
Let's read her evidence. I think that's better.
Because before going to her evidence, my lord, I'm just pointing out things, my lord. I'll draw my lord, because that is the only case, my lord. PW7
yes,
is at page 69.
Correct.
My lord, may kindly see page 69, paragraph 2. After solemnization of my marriage with deceased Ananta on 15/2/89, I used to reside in his house at Palace Line, Balangir, along with my in-laws, including accused Achyuta. However, as my husband was entangled in a murder case in the month of August 89, I used to reside with my parents in village Chudapal. Thereafter, my husband was confined in jail custody. In his absence, my parents-in-law harassed me, for which I went to Chudapalli. After acquittal of my husband, again I joined him and resided with him in his house after lapse of 2 years. Thereafter, also my parents-in-law harassed me, finding no other way, myself and my husband, along with our daughters, decided to reside in my parental house at Chudapalli and left Balangir about 9 months prior to the occurrence. Occurrence took place on 17/4/96. Prior to that, the deceased came to Balangir on 12/4/96. On that day, when he returned to Chudapalli, he told that he would drive a half-ton vehicle purchased by his family members. On 13/4/96, which was a Saturday, my husband left Chudapalli, saying that in case he was required to take the vehicle to some other place, he would return on the following day. My husband did not return home till the morning of 17/4/96, for which I became worried. And at about 10 a.m., I left Chudapalli to inquire about the whereabouts of my husband. On my arrival at Balangir, I walked towards Palace Line from the private bus stand, accused Achyuta has a shop in the name and style Sonali Electricals in the Palace Line. On my arrival in the Palace Line at about 12 noon, I saw accused Achyuta dealing sword blows on my husband in front of his shop. As a result of such a shot, my husband sustained injuries and fell down. Seeing the incident out of fear, I returned to Chudapalli and disclosed regarding the occurrence to my father. On hearing regarding the occurrence from me, my father along with me came to Balangir at the same day. At Balangir, my father left me at bus stand and went to inquire regarding the incident. He returned and told the dead body of my husband had been taken to hospital for postmortem examination. We went to the district headquarters hospital, Balangir, where my husband's dead body had been kept. After seeing the dead body from a little distance, we returned to Chudapalli. Cross-examination by appellant. I have passed matriculation this year. I appeared for the state examination in the PR High School, Balangir Center, in the month of April 1997. My father used to accompany me to the examination center from Chudapalli every day. I have another sister and two brothers. My father, who was a primary school teacher, had already retired from service during the period of occurrence. One of my brother is married and he has two children. My sister was unmarried at the time of occurrence. Myself and my husband were residing with my parents, brother, sister, and their family members in Chudapalli. My sister's marriage was solemnized in the month of May 96 after this occurrence. My father's elder brother, daughter Pramodini, has been given in marriage at Rugudipada in Balangir town. Also, one of my father's sister has been given in marriage at Brahmanapada in Balangir town. I cannot say the registration number of the buses in which I came to Balangir from Chudapalli on the date of occurrence. I am also not aware of the names of the conductors and drivers of those buses. As my husband had told that he might be required to drive the vehicle, and as he had gone to his house, I did not send anybody in search of him till Wednesday, that is the date of occurrence. I did not bring any of my children to Balangir when I came to inquire regarding my husband on 17/4/96. I have two daughters, aged 7 years and 5 years, respectively. The girl standing with me in the dock is my youngest daughter. She, being young, always stays with me. I cannot say the approximate distance from the private bus stand and accused Achyuta's shop. I do not remember whether shop and markets were open at the time of occurrence. There are shops on both sides of this spot from which I witnessed the occurrence. I do not remember what articles are sold in those shops. I never went to accuse Achyuta's shop volunteers. His shop is on the way. Witness appears to be indisposed of and upset. Then, paragraph 12. I cannot say if the route from bus stand to my husband's house through Women's College is the shortest route. I have not seen Women's College Chuck. I cannot say whether on the date of occurrence I passed through the Women's College Chuck. It is not a fact that accused Achyuta's shops, Sonar Electrical, is not on the way from private bus stand to my husband's house. It is a fact that there is a chuck near the spot. On an earlier occasion, while passing by my husband had shown me accused Achyuta's shop. I never went to the shop area, shop on any occasion for purchasing any article. I witnessed the occurrence from a distance of around 20 to 25 cubits. I cannot say whether my husband, accused Achyuta, saw me at that time. Husband or accused Achyuta saw me at that time. I cannot say at what distance from the edge of the metal portion of the road my husband was assaulted. My husband was facing towards me. I did not raise any noise. I did not notice anyone else in the vicinity at that time. I do not recollect if any pedestrian was present nearby. I do not recollect if there was transaction in the nearby shops at the time of occurrence. It was valued around 12:30 to 12:45. And that Palace Line area is the very busiest area of Balangir town. It is a fact that Office of Superintendent of Police is situated on the way from private bus stand and the spot. And that town PS is situated near the private bus stand. Out of fear for my life, I rushed back to Chudapalli without lodging any information in the SP office or at the town PS. I did not go to the house of my father's sister or my father's elder brother, daughter, because I never used to visit their houses. I cannot say if the house of my father's elder brother's daughter, Pramodini, is situated on the way from private bus stand to the spot. It is not a fact that before leaving for Chudapalli, about 9 months prior to the occurrence, I was staying in the house of above said Prabodhini, and that I had sent intimation to my father with Usha Das, a lady health visitor. It is not a fact that after my marriage, I never go out alone or unescorted. I cannot say the registration number of the buses in which I gave the date of occurrence. I commuted in private buses. As soon as I returned from the spot to the private bus stand, I boarded a bus which was going to Kontamanji via Patnagar. Seeing the occurrence, I was shocked, and all along, tears rolled down from my eyes. Neither any of the passengers spoke to me, nor did I speak to anyone my way from Balangir to Chudapalli. I do not recollect the identity of the conductor or the driver or any of the passengers of the bus in which I traveled. It is not a fact that I have not seen the occurrence. It is not a fact that accused Achyuta never assaulted the deceased and that I am speaking falsehood. I have heard about Kamala Mishra. My husband once told me that he happens to be one of the maternal uncles. It is not a fact that for the first time I learned regarding the occurrence from Kamala Mishra at Chudapalli, when he was said to intimate me regarding post-mortem examination. I did not beat any police officer on 17/4/96. I was examined by police on 18/4/96 at Chudapalli. It is not a fact that on 17/4/96, after post-mortem examination of my husband, I and my father demanded rupees 25,000 from my father-in-law for solemnization of my sister's marriage. Having waited for 3 days, I became worried and desperate, for which I came to Balangir to ensure about my husband, inquire about my husband on 17/4/96. There is no other special reason for not coming to Balangir earlier. Accused Achyuta's shop has been named after my eldest daughter, Sonal. Present appellant is the younger brother of the deceased one. It is a fact that when my husband was entangled in a murder case, my father-in-law, as well as accused Achyuta, helped in defending him. It is a fact that accused Achyuta also financially helped us when my husband was suspended from service. It takes about an hour from Balangir to Chudapalli by bus.
What is your defense?
My defense, my lord, is, in fact, President appellant had a very good terms with his elder brother, my lord, for which even the shop, he was unmarried. Even the shop where his own shop was named after his niece, my lord. They had a good relationship. The reasons best known to, my lord, the prosecution or to PW7, my lord, that why my lord must have seen or must have relied upon or must have referred that, my lord, of court a judgment, my lord, 81 Supreme Court 765, Shankarlal Ghiaslal Dikshit versus State of Maharashtra, my lord, where it has been held by the Honorable Apex Court that mysterious is the working of human mind. Why a person is come forward to depose, only he or she can say. That has been taken note of by this Honorable Court and afterwards by Honorable Apex Court in number of cases. This question comes up very often in the mind. Why? What made her to depose? If the relationship was good, everything was good, what made him? Made her to come forward against the present appellant. The defense, I was expecting this question from my lord. My lord, I was verified from the accused statement. Question number 27 was put to the appellant. He said nothing was there. While postmortem was going on, I was there.
Yes.
The PW7 and her father asked me about 25,000 so that the marriage of a younger daughter can be solemnized. And as because he was mentally upset for the death of his own brother, he said, no, nothing can be done at present.
What's the alternative? Who else killed the brother and What is that story?
My lord?
Who else could have killed the...
Yes. He was involved in two cases, my lord. In a case of murder and just before the occurrence in a case of 307. There might be, my lord, a person who has been acquitted. He's not free from enmity, my lord. The persons who, from the side of the deceased, they always keep a grudge. Yes, he had killed my brother or niece or nephew, but he has been acquitted because of lack of evidence. But that remains, my lord. It was there. And, my lord, another things, my lord, that comes
in the 302, he was acquitted.
My lord?
The deceased was acquitted in the 302
302 and 307 also.
Yes.
And, my lord, what happened, my lord? Here, initially, charge was framed against three persons, 302 by 34.
Yes.
302 by 34 charge was framed by the Lord trial court. But as because witnesses did not say anything about other two persons, though that was their statement in 161. Even the PW7, I was going through the 161 statement of PW7. She has also stated the presence of two persons, but she has given the complete go by while she has deposed. Another things, my lord, which I believe my lord will take note of. PW8, before going to that, my lord, I just want to draw my lord's attention. PW8 is the investigating officer. He says he has examined PW7 on 18th at Chudapalli. But he has not stated a single word from which source he could know that PW7 has seen the occurrence. And why I am saying so, my lord, PW7 has not volunteered, even after one day, that I have seen the occurrence, I should be examined, I am the wife of the deceased. She has not come forward.
Even in her 161, there is no such statement.
My lord?
In her 161, there is no such statement. No, she has not said that in her 161 statement. The PW7,
yes,
in her 161 statement,
my lord,
has not said that she has witnessed the occurrence.
Yes, she has stated so. She was examined one day after.
Okay.
My lord, belated disclosure, my lord, beginning from 76 Supreme Court 2488 to till date, court has disbelieved even, my lord, the delay of examination of sole eyewitness, because here is the witness who is the sole eyewitness to the occurrence and happens to be the wife of the deceased. My lord, law is very clear and well settled that conviction can be based on the evidence of a solitary eyewitness if the evidence is clear, cogent, and unimpeachable in character, and above board. My lord must have argued and must have decided number of cases on that. Section 134 is very clear. 134 Evidence Act is very clear in that aspect. And when that sole eyewitness happens to be the relation of the deceased and taken to be a chance witness, how that evidence will be approached, that has been taken note of by Honorable Apex Court, my lord, in 98 Supreme Court.
No, just to go back to where we were. So the IO meets her at Chudapalli on one day.
Next day.
The very next day after the occurrence. That is on 18th April.
My lord.
On that day, she does not tell him anything about having witnessed the occurrence.
Yes, she has stated so.
No, but you said there is a delay in her saying that.
Delay, 17th is the affair, 17th is the occurrence, where she was present at the spot. She has not disclosed before anyone that I have seen the occurrence.
No, she went back to Chudapalli.
She went back on the way, Ballard SP office, town police station. She has crossed everything.
Correct.
And went back and called and informed the same to his father.
Right.
Her father.
Right.
Father has not been examined, madam.
Right.
Father, along with father, she again came to Balangir.
Right.
To the postmortem center. There also, my lord, there must be gathering, my lord, in the postmortem center in the district headquarters hospital. There she has not disclosed before anyone. Again returned back to her village in the evening, 17th evening. Then, my lord, 18th, she remained in her own house. Then, my lord, at night, evening, my lord, PW8 went to her house to examine her. But which source he could know that she has seen the occurrence? Nothing is there on record.
No, but I'm saying it's very natural for a police officer to go and inquire from the family members of a deceased.
Yes.
So it does.
My lord,
he does not have to know.
My humble submission at this juncture is, my lord, occurrence is 17 April to 96. FIR was given to the court on 19/4/96. FIR was sent to the court on 19/4/96. If the statement was there, statement of PW7 was there, it must have been accompanied along with that FIR. My lord, again, I want to say why that has been created. My lord, I was verifying the records also, lower court records the lawyer has given, my lord. The record was prepared when the registered civil court Balangir wrote a letter to SDJM Balangir that record of GR case number so is required for disposal of a criminal case filed before the Sessions Court. My lord will see from the record on 5/9/96, the Lorraine SDJM has sent the record containing 4 pages. My lord will see 17/4 and 5/9. No investigation was done. Nothing was done. Nothing was sent to the court. Why, my lord, then section 167, 172 is there in the court? Only to prevent, my lord, only to prevent that this type of embellishment and exaggeration should not be there. Each day records will be transmitted to the court and court will sign it, SDJM so and so, date. That is the purport of the statute, my lord. It's not an empty formality. My lord will see from the record that for the first time, a letter was received from the SDJM, from civil register civil court Balangir, that was addressed to the SDJM. SDJM, my lord, sent the records to court to register containing 4 sheets. So 4 sheets, my lord, I was also verifying that this affair contains 4 sheets. Nothing was there beyond that. Can it be taken into it will be accepted as it is that record was everything was there and IO has not given it. Sometimes, my lord, what happens, my lord, when we are filing applications for anticipatory bail, records are being prepared, including that accused, implicating that accused. Many times, my lord, I have refused, no, nothing is there against you, don't come to the court. You will be an accused ultimately. And that happens in the present case, my lord. Because my lord will say one thing, PW8 is the informant, he is the investigating officer. He is definitely interested to see that there will be some material against the accused because some accused or some the case should be added in implicating someone. If evidence of statement of PW7 was there, what made him not to send it earlier? Well, that has been taken note of by an old judgment, my lord, I was verifying, 57 Andhra Pradesh. I'm just drawing my lord's attention, my lord must have seen that. My lord, it's very pertinent, my lord, the judgment has not been, though has been relied upon by Honorable Justice Kaul in a recent judgment, has not referred this judgment. But this judgment is very, my lord, 57 Andhra Pradesh, 561 by Honorable Justice Chandra Reddy and Uma Maheshwaram. My lord, here, the Honorable Court was pleased to observe. Coming now to the prosecution case, we have to consider the effect of the failure of the officer concerned to send a copy of the entries in the case diary. From this omission, it may reasonably be inferred that they had not come in existence by the time or at any rate in the shape, in this shape in which they were on 2nd August 1954. It is unlikely that PW1 would not have thought of transmitting a copy of the entries if the material witnesses were examined by that time and they had given him information consistent with the theory put forward by the prosecution. So this is not an empty formality, my lord. This is not an empty formality, my lord. I may be wrong, my lord, in my submission. My lord may verify from the records. Letter of Lord register civil court to SDJM and SDJM's letter to civil court, and ultimately, my lord, so CSI's letter to IIC to send the records. If that statement would have been available with the investigating officer, again I verified, my lord, from the order sheet of the Lord Magistrate, it would be seen that affair has reached the court on 19th. Affair was lodged on 17th at 1 p.m., but it has reached. If the statement was available, statement of PW7 was available on 18th, and that is, she is the star witness in the occurrence, and wife of the deceased, what made the investigating officer not to send the statement along with that record? That has also been taken note of by this Honorable Court as well as by Honorable Apex Court, by recent judgment of Honorable Justice Kaul, wherein this sending of the affair one day after the occurrence and sending the records subsequent, that speaks loud, my lord, that language used by Honorable Justice Kaul in 2010, Volume 2 OLR, Supreme Court, 908, Amar Singh versus State of Delhi, NCT of Delhi. My lord, the Honorable Apex Court was pleased to observe the appellants before the High Court was that there was unexplained delay, not only in the lodging the affair, but also dispatching a copy of the same to the magistrate. In absence of any cogent and acceptable explanation to the delay, the prosecution case was rendered doubtful. Here also a case of solitary eyewitness, and court has disbelieved that eyewitness because of the fact that also delay was there, belated disclosure. My lord, question comes up that, my lord, to put a very relevant question, that IO went to the village of PW7 to examine her because she is the wife of deceased. Question again comes up, my lord, for appreciation of evidence, her evidence. What made her not to disclose before anyone? She knows the accused concern here is her own brother-in-law, and he is not involved in any case. He is not a criminal. He is not a hooligan. He is not a history cheater. What made her not to disclose? That too on the way, she has crossed the police station. She has crossed the SP office. She has gone to her own village. There she should have informed the Sarpanch or any village entries that I have seen such and such things. What made, my lord, the prosecution to suppress the evidence of PW, my lord, the father of PW7, who had accompanied with his daughter to Balangir? My lord, in a criminal case, my lord, it depends upon appreciation of evidence, my lord. It's not that 1 + 1 is always 2 in criminal case, my lord. Here, if my lord will appreciate the evidence of PW7, who says that I had a good relationship with the appellant, paragraph 23 is very clear that when my husband was accused in a case of 302, he has helped me a lot in defending the case. While he lost his job, the appellant has also helped him for survival and also has purchased a vehicle for him. And one peculiar thing, another peculiar thing which I want to draw my lord's attention, if the evidence of PW10 will be considered, it will be seen, my lord, he has received not less than 20 injuries from top to bottom and different parts of the body, including front, back. My lord, can visualize a situation in the open road. Can a person will give in having 4 weapons, assault of the front side, back side, leg, head, abrasion, contusion, incised wound, everything, all 4 weapons with 4 hands. Back, front, leg, hand, everything. A case can be cooked up, but not in this way. A appellant has been implicated. For that reason, my lord, I was drawing my lord's attention to 81 Supreme Court 765.
Yes.
that mysterious is the working of question comes up, whether the language used by the apex court is very clear. They have summed up the entire material. My lord, in Sankarlal Gyaslal Dikshit versus State, our judgment will raise a legitimate query. My lord, at paragraph 33, Honorable Justice Chandrachud and Justice Epishen and Bharulal Islam, my lord, they said, my lord, in paragraph 33, our judgment will raise a legitimate query. If the appellant was not present in the house at the material time, why then did so many persons conspire to involve him falsely? The answer to such question is not always easy to give in criminal cases. Different motives operate on the minds of different persons in the making of unfounded accusations. Besides, human nature is too
Mr.
willing.
Gala, if I remember right, that's a circumstantial evidence case. Sankarlal.
Yes, but I will say this principle of law has been taken note of by our High Court in a case like present one. I'm quite conscious that it's a case but with regards to why, question is why a person comes forward. Mysterious is the Honorable Justice.
No, because I think that was in the context of motive, correct?
Yes, I'm saying that. I'm saying. But this judgment has been taken note of like a present case of present one, where a witness was there. But where this Honorable Court.
What's the citation?
That is ballot 85, volume 1, Whaler, page 421, Madkami Raja versus State. Madkami Raja versus State. Here, solitary witness was there. Madkami Raja. My Lord, may see paragraph 8. It had not been brought out by the defense as to how and why this witness would be hand in gloves with the prosecution and depose falsely against the appellant. But mysterious is the working of human mind. And it is not always possible for an accused person to say as to how and why a case has been foisted against him. And some witnesses have come forward to depose against him. In this connection, it would not be out of place to quote an extract from decision of the Supreme Court, AR 81, Supreme Court 765, Sankarlal Gyaslal Dikshit versus State of Maharashtra. Same paragraph has been quoted, paragraph 33 has been quoted. Here, my lord, similarly, solitary eyewitness. Then question comes up why he has come forward to depose against you. And the answer is, well, I do not know. How can he say? Only he asked me 25,000, I could not pay it. And that has been, my lord, negative. Her story has been negated by the medical evidence. If the medical evidence will be believed, doctor says these injuries cannot be possible by one person. But rather, the prosecution initial case was 3 persons were there. They have given a complete go-by to them. They have been acquitted under section 232 CRPC at the stage of accused statement. My lord, in that aspect, my lord, I want to draw my lord's attention to 98 Supreme Court, page 249. Srimati Anuvati versus Mahendra Singh and others. Here also, my lord, around 17 to 18 injuries were there. One accused. The judgment, my lord, by Honorable Apex Court, by Honorable Justice Punchi and Justice Srinivasan. My lord, here, my lord, paragraph 9. Books. In the case like Budget 1, my lord.
Yes.
The said doctors, towards paragraph 9, last 8-10 lines. The said doctor stated that the postmortem examination report does not show that the injury was caused by more than one blow. Considering the fact that as many as 17 incised wounds were found on the body of Rajkumar Singh, the High Court found it difficult to believe that he was assaulted by only one assailant with a sharp cutting weapon. The High Court opined that there were more than one assailant armed with such sharp-cutting weapons. The opinion of the High Court cannot be considered to be baseless or perverse. Here, my lord, the government appeal has been dismissed. Appeal filed by the informant has been dismissed.
All right.
Here, my lord, the case is, my lord, if a person will be assaulted, my lord, it's a normal. It's a normal, my lord, thing. If I will assault X with a sharp-cutting weapon, after 3-4 assaults, he will fall down. After 3-4 blows or 5-10 blows, he will fall down. But he has received abrasions, contusions, even, my lord, injuries with dent. Dent means, my lord, usually used for cutting ships, my lord. That has been used. And abrasions, if I have got a weapon, say sword, say bhujali, say any sharp-cutting weapon.
No, so no bystander has been examined.
Not a single bystander has been examined, my lord.
And this is 12:45 noon.
12:45 noon, that to a busy place in Balagi town, Palace Line. But I know, my lord, almost all senior lawyers and all big business centers are there in Palace Line. And that too, if she has ballot by 70s, I have not yet drawn my lord's attention to a off-court judgment with regard to belated disclosure. My lord, a case of this nature. He said, my lord, Honorable Court is a very small judgment by Honorable Justice Raghavati. It is a case from Orissa, my lord, against an order of acquittal. Where in a murder case, the entire prosecution case depends on the evidence of a person claiming to be an eyewitness, and this witness did not disclose the name of the assailant for a day and half after the incident, and the explanation offered for non-disclosure was unbelievable, held such non-disclosure was a serious infirmity. Here, the reason for non-disclosure was there could be no question of any fear from the respondent, because in the first place, the respondent was not known to be a gangster or a confirmed criminal about whom people would be afraid. Here, the person concerned is her own brother-in-law, and who was supporting her family whenever the family was in distress. So, no question of fear. She could have very well disclosed, because she has covered from Palace Line to bus stand around 2 kilometers. Anyone, because it's a ghastly murder case, not that it's someone has some minor injuries have sustained. She has seen the occurrence. And that too, she has got relations at Balangir. She could have gone very well there and say, my husband has been killed by his brother. Please do the needful. I'm going to my native place. Instead of doing that, she returned back to her father's place, reported the incident to her father, came back to Balangir again. When she has come back again to Balangir, must have courage to come. She had gone to the hospital while postmortem was going on. There, my lord, they have demanded 25,000 from the appellant. Appellant said, I cannot pay now. So they returned back, stayed there in their house. Next day, my lord, police has introduced her, or my lord, that has been created later on, that my lord can decide. Because my lord has already drawn my lord's attention to the order sheet dated 4/9, 5/9 and 5/9. 3 orders, my lord, 3 letters communicated from register to SDGM, SDGM to register, and CSI to IIC. If the and back to very, very important is the letter of Lord in SDGM, where he said sending 4 sheets. Now, what is 4 sheets after 5 months? If the name of the accused was very much available on 18th, at least 10 records will be there that yes, I have searched the house, I could not find him, he has absconded, this, that. It was not there. Nothing is there. My lord, may see. I've got the rough copy for which I have not been daring to show it. But my lord can see it from, my lord, it's from court. That barcode, my lord can verify that. And I will develop my argument on that also. tomorrow or day after, if my lord will take up and develop.
It's a lot of time.
My lord, if that will be there, my lord, then I have.
No, the record must be here. LCR is here.
No, LCR is not there.
No, the soft copy is there.
My lord, that can give, my lord can verify that.
Yes, yes.
If that will be found to be correct, then my lord, entire case goes, entire prosecution case goes, my lord.
So where is the LCR? Do you know in the exhibits, list of exhibits?
No, that is barcode, my lord, is company.
There's a separate case diary.
That will be new. That is with the, I think, with LCR, my lord.
That's right. In the LCR, there's a separate case diary.
LCR, my lord, online decisions, court LCR, you would be show everything.
No. Where exactly do you want to refer in that?
That is, my lord, order of law and SDGM's court record. It's very much there in the record. First, ballot will see order dated 19/4/96, seen the affair in town PS case number 52 of 96 under section 302. So affair was lodged on 17/4. It was sent to the court on 19/4. If ballot will permit me, then I can take the copies and I'll.
All right.
If ballot pass order to take the copy from the court, so I can give it in spiral binding.
Mr. Dallas states, senior counsel opinion for the appellant is permitted to obtain a soft copy of the LCR on a pen drive from the registry. So when do you want it? Next week?
Well, any date.
All right. Next Tuesday?
Next Tuesday.
6th.
Well, 6th.
Yeah. List on 6th.
September. Yes, madam, on 6th.
All right.
I draw my lord's attention with regards to the judgment of 81 Supreme Court 765 that has been also taken note of in 2020 Supreme Court in a case of this nature.
Right.
So I'm quite conscious that Ballot Sangarlal Giasal dikhi the case just on circumstantial evidence, but the principle of law is same for everyone, everything.
Right.
Well,
Wiki list item number 3.
I don't know, 3 months. I have not received the paperwork, minutes. Let it be taken up next week.
It will stay on board, sir. You better collect the paperwork. Nobody will come and deliver it to you. You have to go out and collect it.
Paperwork is not available with the registry.
No. Paperwork is very much available, sir.
Yesterday, my lords have verified, my lords.
Just open the.
I have gone to the office, my lords.
1 minute. Just open it.
That's why I am praying to the.
1 minute, sir. 1 minute. We'll eliminate this excuse right now. Take this. Just give it to him. Now received?
Kindly taken out next week.
Yeah, no. It will stay on board. You get ready with the matter.
Subsequent to matters are there 2020. That's the field. After that,
Sorry?
20 and 21 items.
Maybe
after that.
Okay. But these are all very old cases, which is
I'm doing. I'm no, I'm doing.
Weekly list item number 4.
Because item 4, I'm sorry, because my my file has been misplaced. The matter was heard earlier. As I remember, your Lordship may give me 10 days time to collect the papers from your Lordship. Your Lordship may permit me to take records from your on payment of money.
No, you take a soft copy and get it printed out at your end.
Yes, if it can be given,
You just send the pen drive, you'll get the whole soft copy.
All right, I'll give it.
So we're not going to pass separate orders. You just do it, sir. We'll give an instruction to them. Whoever wants a soft copy will get it. No need to pass individual orders.
Obliged. This is an old case. I am 22-year-old case, but somewhere the file has been.
We should prevent it silver jubilee.
No, Millers, I had argued this matter before Honorable Justice S.K. Misra. Somehow or other, the judgment was not given. I remember I had argued this matter.
All right, sir.
Weekly list item number 5.
Item number 5, Lordship.
Samir Mishra. He's probably not well. Yes, she's probably.
Item number 5, Lordship. I'm the virtual mode, Lordship, on behalf of Mr. Mishra.
Yes.
Lordship, I pray for layover for the next week, Lordship.
Yes, all right.
Weekly list item number 6.
On behalf of Mr. Jikenai, he's suffering from fever. I pray any date next
stay on board. It will stay on board.
Weekly list item number 7.
7 Iceland next week.
Sir, is there anyone who's ready to argue? Everybody is only saying next week. It's all 22-year-old matters, sir.
Yes, I know.
How does it help your client? Tell me. Anyway, it will stay on board. We're going to call it out every day. Yes, Miller.
Item number 8.
You better get ready with it today, sir. You go back today and start getting ready with the matter. It's not all these matters are not very complicated. I'm telling you only.
Miller.
So it will be called out again tomorrow. So you better get ready.
Yes, sir. Tomorrow I will make it ready.
Weekly list item number 8. Item 8.
Who's from the state side?
May I submit something, madam?
Yes.
Lord, of course, I am not asked for it, but so far because your lordship said that who is ready, then let him come.
Yes.
What happened, my lord? In earlier occasions, they used to give a list of ready cases. So in that case, we get breathing time and we get the paper book, and also sometimes this matter is ready. But it is after 20 years, anticipating that the number of benches, increased. I had this will be probably after.
Which is why we are allowing it all to stay on board.
No. I'm not.
Whoever is ready should get ready with the matter.
I'm just to add to your lordship. The whole point is that I never saw the chief justice hearing 302 questions. Your lordship is trying for that, and the disposal is very good. We are happy. But the point is that will add to your lordship's desire. If there's ready cases will be published, so all the laws will come to know these cases are ready, and like any time it will come, so that they can also collect the paper book. Before your lordship, this matter was listed. My matter is way back in 1913. Item number 39.
39.
Now, anticipating that the matters may come, because after 20 years there was no order at the time when the bail was granted. So, virtually we lost track with the client. We never got the opportunity to hear the appeals, because if your lordship will ask me, I'm 99.9% a high court practitioner. I don't have a trial court practice. So after the admission, about 100 appeals are there, which is not listed for 2 decades, 3 decades.
Right.
One appeal I argued, that to jail criminal appeal, way back in 1987. Not 87, 85, 86 by Justice B.K. Behra.
Okay.
So the whole point is that it's good that it's taken up, But if that is further is given the ready list for future cases which are not before your lordship board now, because it is after listing in the lordship board, we come to know this ready.
Right.
But before that, I have sent around 30 case registered letter to my client anticipating this.
Okay.
That you, wherever if you are there alive or anything interested, come. So the whole point is that today morning I got a message from the advocate that he received the registered letter of the client and he approached the lawyer and he is getting ready to come.
All right. So we'll accommodate all of you. There's no difficulty. Wherever you want to be accommodated, we'll accommodate you.
But if your lordship will direct the office to make a ready list, which was there,
I'll do that. We'll do that. We'll do that. We'll do that.
Earlier they were publishing.
All right. We'll do that. We'll do
that. Will further add to your lordship and it will more fun. Your lordship will not have to ask that anybody who is coming ready. Because now your lordship find nobody is ready.
All right. All right. We'll do that. We'll do that.
Of course, it's all on-shot for, but I thought that because your lordship said...
No. Much appreciated. We'll do that. Right.
Item 9.
You're waiting for?
Sir, item number 10, my lord. I have no paper book, my lord.
So you'll also collect it, I think, we'll give it to her. Just give her a paper book, man. Item 10. All right.
That is the case what I have seen yesterday, my lord. They have assaulted by kicks and fist blows, my lord. Therefore, my lord, this case falls under section 304 part 2, man.
Let's see that. You get ready with it.
Yes.
It will stay on board. Not difficult.
You have to pay something for this.
No, not necessary. We are more keen that the appeal should be heard.
As per the High Court rules, we have to pay.
But you have to endorse, that's all.
Oh,
same matter. Oh.
My prayer, my lord, let this matter may be taken up day after tomorrow. You also may kindly accommodate me for day.
No problem. No problem. Anyone else who's ready to argue the matter? Any of the other counsel in court, please? All right. You come back. If anyone.
I pray, my lord, item 11. I pray, my lord, I have not collected the paper book, my lord.
You collect, so whoever wants paper book, just collect it from
Yes, I have a small prayer, my lord. Item 30. Though in two appellants were there, my instruction, because I cannot definitely make a statement. One has died.
Oh.
It will be two appellants. The other is there.
Okay.
I will receive the paper book just now.
Right.
Your lordship may fix it to next Tuesday.
Sir, Lord, stay on board. You just stay on board. We don't want to keep on adjourning, passing orders unnecessarily.
All right. Only let them take that instruction so that it can be put on record.
All right. You tell them. No problem.
Next Tuesday or any day they come up with that instruction, I am ready.
Right.
I need a day or two.
All right.
I am receiving the paper.
All right.
My lord, I beg your lordship, my lord. Item number 17.
Yes.
My lord, the same thing is with me, my lord. The appellant number 1, at the time of filing this appeal was aged about 70 years. I am not sure, but I have just received the information from the local council that he is no more.
Oh.
So if your lordship can call for a report from the local police, because that is, I'm not sure, my lord. But
All right, she's making a note of it. Item 17 also. All right.
And my lord, another matter is there on item number 36. My matter. From tomorrow till 6th, my lord, I'll be absent. I'm going out for the admission of my son. So I may be accommodated for that item.
Item 36. Just make a note. All right.
Pardon, my lord. Item 34 and 50. Mr. D.K. Mishra was the counsel for the appellant is in the government panel. So I humbly pray 1 week after it will be taken up.
So we'll all stay on board. Meanwhile, you get your wakalatnama and all that.
Yes, sir.
Anyone else? All right.